this particular topic, and it is very contemporary in nature. It is not limited to the issues relating to the developing nations or the underdeveloped nations. But this year itself, we witnessed a protest in the New Zealand Parliament by the members of the Maori group, protesting, singing their traditional song, Haka, in the Parliament and expressing their rights for land rights. Today, the topic of our discussion is grounded to this issue, identity and recognition of the rights of indigenous and fisherfolk of the entire universe. So we have got, as told by the moderator, we have got a dynamic or galaxy of eminent persons here who are bound to speak on that, and it is chaired by, as Mr. Shivkumar told you, it was supposed to be chaired by the Honorable Judge of the Supreme Court, Mr. Narasimha, but unfortunately he has to leave abruptly due to abrupt demise of his relative at Andhra Pradesh. So he took excuse for that, and he is replaced by none other than Mr. Venkataramani, the learned Attorney General of India. Yes, sir, on behalf of the organizing committee, I extend a warm welcome to you, sir. The session is co-chaired by the Honorable Chief Justice of Telangana, Justice Abresh K. Singh. I warmly welcome you, sir, on behalf of the organizing committee to this session. We have got a person who is the Chief Conservator of Forest and Head Forest Office. Okay. The theme of the session will be presented by the Vice Chancellor of QFOS, Professor Dr. A. Bijukumar. I extend a warm welcome to you, sir. Now we have got four speakers in this session. Dr. H.J.F. Silva, Vice President CLEA from United Kingdom. He is the senior most member of our organization. Sir, a warm welcome to Trivandrum. Mr. Charles George is the State President of Kerala Matsyathozhilali Aikyavedi, that is the umbrella organization of all the fishermen labor organizations in the state. I extend a warm welcome to you, sir. Today we have amidst our Miss Dr. Manjusha K.A., who is the Assistant Professor of School of Gandhian Thought and Development Studies in MG University, who has got ground knowledge about the various issues affecting the two vulnerable communities, that is the fishermen as well as the tribal population of the state. I will extend a warm welcome to you, sir. We have got discussants, Professor Dr. Rose Vijaysekhara from the head of the Department of Private Comparative Law, Faculty of Law, University of Colombo, Sri Lanka. Dr. Preetha, who is the Associate Professor of School of Legal Studies. Dr. Anida A. Patil, Associate Professor of Law, Ramaiah College of Law, Bangalore, Joint Secretary, CLEA Asia, and Dr. Nabila Sera, Doctoral Scholar, Indian Law Institute, Convener, CLEA, and Mr. Varun Dev, Assistant Professor of the Kerala Law Academy, Law College. I extend you all a warm welcome to this session. Sir, last but not the least, the vibrant, dynamic, great orator of this session, moderator. He is a barrister from United Kingdom and is the Secretary General of Bangladesh. I extend a warm welcome to you, sir. Thank you. I also welcome Mr. Raman Rajamannan. He is the tribal king of the Mannan community, of a prominent tribe in the state of Kerala, and he represents the autonomy, self-autonomy of the tribal people of the state. So I welcome you on behalf of the organizing committee. I welcome all the participants once again to this session. Thank you.
This is my turn to invite you. And just we are entering into the discussions. Before doing that, I offer my sincere thanks to reporters. Thank you, reporters. You are the heroes of the day. Sir, Honorable Chair, as already announced, and very known face, Learned Attorney General for India, patron to CLEA, a lawyer, a poet. Sir, this is your turn, sir.
Good morning to all of you. And since there are a number of speakers and discussants, I think the chair should not speak much, the chair should listen. But let me share with you a few thoughts. When you talk of recognition or identity of any set of people, and want to move towards a legal framework that will be appropriate to ensure that they get their due process and get their dues in the midst of all social conflicts and competitions and the competition for sharing social, economic, political, and natural resources. A couple of questions come up to one's mind. We have been for long following a very conventional or a traditional method of English lawmaking. The framework of a law, the designs of a law, mostly follow this pattern. You look at some of the major legislation, you will find definitions and then some rights granted or some institution established, the rules and regulations relating to functioning of the institution, and then we have a dispute resolution mechanism, mostly the civil and criminal courts. Now, personally speaking, and looking at what the adversarial system has done for our country, I became a great doubting Thomas of the adversarial system. The adversarial system has its limitations. It is a limitation because the way law is framed. It is a limitation because the way we actors or players in the system make it good or worse. So the adversarial system does not admit of flexibility. We have procedures, good, but then procedures have their problems. The judges and the lawyers are the masters of interpretation, these procedures. So you have a huge expanding books of interpretation of legislations and statutes and so on and so forth. It's time, therefore, when you think of very special sections of people like the tribal people, like yesterday when I said, I would like to move away from the use of the expression indigenous for a number of reasons, but let it be so. We talk about the tribal people and the fisherfolk. They had lived in their own way, in their own understanding of relationship with nature and the bounties of nature. I think they drew lines where they will not exploit nature. They would like to live in harmony with nature. But now all that harmony and coexistence has become probably victims of the huge development process which has taken all over the world. All of us would like to have development, right? Because we sit here and today technology is such a great boon. So if that is not there, probably we would not travel, we would not talk, we would not do research, probably even we would not do good teaching in the classroom if technology is not available to us. Therefore, somewhere it's a good thing to happen. But at the same end, if we are to not to draw a line somewhere where yesterday the Surikant talking about what Gandhiji said, needs and greeds, right? We really do not know today how the economy markets our mind. It virtually markets our mind. It sells our mind, it sells our thoughts, it sells our transactions, and therefore we are caught in that. We do not know how to get free from that unless we become masters of the process. Going to be too complex because the globe is involved in it, not only India. And in the midst of all this, how do you ensure that this very special class of people get a due recognition identity? And for that purpose, I would like all of you to focus not in the traditional way of either looking at a legal framework or the way law should be designed, but to do something out-of-the-box thinking to find out how to ensure that these two class of people with a symbiotic connection with natural resources remain either the way they are without losing on their right to a good and fulfilling life. The American Constitution talks about pursuit of happiness, but India looked at pursuit of happiness in a very different way. Therefore, it's important for us to say, ensure that on the one hand, this special class of people receive what is due under the Constitution and our the principles of justice. At the same time, we should not probably destroy the very basis, the very foundations of how the relationship with natural resources have existed for long. It's going to be a complex task. To conclude, I had some exercise in drafting a legislation for the construction workers. Under the chairmanship of Justice Krishnaiah, for about 5-6 years worked on this draft. So we're trying to understand how construction workers, who are a mobile set of people, who migrate from work to work, from employer to employer, how do you really ensure that they get their accident benefits? Women get their other, social justice benefits. It took a long time for us to understand how we can design a law for them. At the end of the day, when we found that we can certainly design a law, and became a law somewhere in 1992. And I'm glad the law is working very well. But then the law was very different. It did not go on the conventional lines of understanding employer-employee relationships. Therefore, we need to look at those facets. And finally, if we have to look at a thing away from adversarial dispute resolution mechanisms, it's important for fisherfolk and the tribal people not to get caught in the web of adversarial system. We must provide a system where whatever the disputes are understood and then comprehended and resolved in the most comfortable way. Today, many of us lawyers know when you go to courts and practice, people who come to court in a criminal court, you don't feel comfortable there. A judicial system or a system of administrative justice which does not provide you ease of being at ease and a comfort probably is lacking something in fundamentals. All of us are trying to enhance the quality of the system. But I suppose, as I said, adversarial system cannot be enhanced beyond a point. These are few thoughts I want to share with you, but it's important for us to recognize and identify these set of people in very different ways. If the task be done here today and they're able to carry forward a message for the nation, I'm sure CLEA would have done its best for the year. Thank you so much.
Sir, thank you very much for an excellent, thoughtful delivery and guidance on the subject matter. Now, I take the privilege, and this is my honor, to invite co-chair Justice, Honorable Mr. Justice Apareshka Singh, Chief Justice, High Court of Telangana. Sir, please.
A very good morning to all. Dignitaries on the dais, Honorable Chairperson, dignitaries and guests of the dais. At the outset, I must thank CLEA for giving me an opportunity to be part of this conference on a subject of which I must admit that I'm hardly any depth or knowledge about, but we all live in a society where we encounter from our childhood days interactions and coexistence with various communities, those who have been part of the entire ecosystem in which we live. To start with, I must share my personal experience. I belong to a small village in Jharkhand, and almost every year, a number of times I keep visiting my village. And there are man-made ponds by our ancestors and natural ponds also, fresh water obviously. And there are fishermen communities living there. And we coexist in a spirit of symbiotic relationship. So whenever we request them, of course, they come and do the fishing. It starts from 4 in the morning. What pinched me on few occasions that during their fishing nets get damaged because of lot of broken trees or stumps lying in the water. And they do not have enough resources to buy frequently. I was the executive chairperson of Jharkhand State Legal Services Authority for some time. And therefore, we used to organize legal awareness camps where the benefits of these welfare schemes were distributed, which included fishing nets also. So they used to request me to kindly ask the block development officer or the district fishery officers to give them a fishing net. This is the kind of hardship that these communities face at the grassroots level. For the last 2 days, I am staying in a hotel nearby and just next to the sea. And we have been, with great admiration, watching the boats, fishing boats, day and night on the high seas, and the kind of tough life and the efforts that they are making to bring all varieties of fish and in that process earn their livelihood also. So the experience, these two experiences, which I share with you, in fact, asked me to comment that CLEA has really taken up a very important subject on this occasion, in this conference, and there are learned speakers to speak on this subject. We will be enlightened by their address. I just want to make few submissions. The discourse on sustainability must account for communities whose lives and identities are deeply embedded in natural ecosystems. Indigenous tribals and fisherfolk both represent populations whose survival, knowledge systems, and cultural practices are intimately tied to land, forests, rivers, and seas. Yet, while the constitutional and statutory frameworks extended robust recognition to tribal populations, acknowledging not only their occupation but also their socio-cultural and spiritual relationship with land and forest, the same level of recognition remains absent for fisherfolk. For indigenous tribals, constitutional provisions under the 5th schedule, read with Article 15(4)46, along with legislation such as Forest Rights Act 2006, PESA 1996, have sought to affirm their rights in a holistic sense. These instruments recognize that their economic activities inseparable from cultural identity, customary law, and self-governance. By contrast, fisherfolk, despite their similar ecological embeddedness and intergenerational knowledge systems, are largely recognized only in terms of their occupation. Policies and welfare schemes address their vulnerabilities in a piecemeal, welfare-oriented manner without extending statutory protection to their relationship with the marine commons as a cultural and traditional inheritance. Their knowledge of the seas, their rituals tied to tides and fishing cycles, and their self-regulatory community practices remain outside the legal imagination, treated as occupation rather than as culture. This disparity raises a fundamental question for sustainability, whether ecological justice can truly be achieved if some ecosystem-dependent communities are recognized as rights-based collectivities, while others are reduced to mere economic actors. The sustainability paradigm requires recognizing both tribals and fisherfolk as communities whose livelihoods are inseparable from their cultural traditions and ecological stewardship. To continue marginalizing fisherfolk by limiting recognition to their role as fishers without acknowledging the cultural, social, and spiritual dimensions of their relationship with the sea risks perpetuating a fragmented model of justice. A more coherent approach demands the extension of rights-based frameworks akin to those enjoyed by tribal communities to fisherfolk, institutionalizing participatory governance over marine and coastal commons and embedding their customary norms into statutory frameworks. In India, a bill was introduced in 2023, and a scheme was introduced known as Pradhan Mantri Matsya Sampada Yojana. The bill, however, did not pass into law. Instead, the government has operationalized PMMSY, a comprehensive umbrella scheme with investment to be implemented from 2021 to 2024-25. This scheme also provides broader social and economic security, introduces insurance coverage for fishers and vessels, promotes advanced technologies like circulatory aquaculture systems, etc., and integrates cluster-based development with institutional frameworks at multiple levels, including the appointment of Sagar Mitras for local support. Critics, however, note that PMMSY and the broader national fisheries policy remain largely production and export-driven, raising concerns about whether their rights and cultural interests of traditional fishing communities are sufficiently safeguarded. The fishermen continue to face hazardous working conditions and human rights violations despite existing law. Challenges include unsafe environments, exposure to pollution, lack of awareness about legal protections, and vulnerability to climate change impacts. Many fisher communities also suffer from generational dependence on fishing without alternative livelihoods. In 2006, the National Fisheries Development Board was established to promote aquaculture in ponds, fisheries in reservoirs, and deep-sea fishing. Yet, despite such initiatives, the livelihoods of fishing communities have steadily declined, exposing the gap between policy objectives and actual outcomes. This decline strikes at the heart of the fundamental right to livelihood, which is protected under Article 21 of the Constitution. Altogether, these concerns highlight the precarious position of fishing communities, underscoring the urgent need for legislative and policy reforms that not only protect their livelihoods, but also ensure sustainable and equitable management of marine resources. Fishermen's rights in international and neighboring waters remain a complex and unresolved issue for Indian fishing communities who face recurring challenges from maritime boundary disputes, resource depletion, and limited awareness of international borders. To resolve this challenge, experts have suggested the introduction of a Fisher Rights Act similar to FRA to grant community-based entitlements over traditional fishing grounds and customary practices, strengthening local governance by institutionalizing Fisher Gram Sabhas with statutory, consultative, and veto powers, alongside codifying indigenous practices, would bridge the gap between traditional knowledge and modern regulation. Technological measures like installing GPS devices in boats and providing training on maritime boundaries and international law have also been recommended. On the diplomatic front, cooperative arrangements such as coordinated patrolling, human treatment of detained fishermen, and regional agreements on sustainable fishing practices could reduce tension. Additionally, establishing an integrated fishing governance through multi-stakeholder councils and judicial guidelines on prior informed consent for coastal development would ensure that fisher folks' rights are safeguarded. Taken together, these measures point to the urgent need for a balanced framework that combines legal recognition, education, technological support, and regional cooperation, enabling India's fishing communities to operate safely and sustainably in increasingly contested waters, while aligning national practices with global standards of ecological and social justice. On this note, I conclude and wish this conference a grand success. Thank you. Jai Hind.
Sir, thank you very much for your insightful delivery. This is my privilege now to invite Professor Dr. Biju Kumar, Honorable Vice Chancellor, Kofus Kochi, and there is a theme presentation. Sir.
Good morning. For the first time, I am feeling a fish out of water, standing amongst the legal luminaries on the dais and off the dais. But my topic is connected with fish, and I have to deliver a few points, and I'm going to open a Pandora's box where the points you can ponder for a longer period of time. Primarily when we discuss about development versus sustainability, because that is the theme which is brought out by CLEA. First of all, let me thank CLEA for the opportunity here. And then, my purpose is to define the blue economy in the paradigm of sustainable development. And as you know, the government's major agenda now is to go ahead with the blue economy and blue growth, where ocean and ocean-based resources are going to be the main focus. And sustainability is the secondary focus, but the primary focus is the ocean-based developmental scenarios. And then we have the national target to achieve 2030 Sustainable Development Goals, where India is a signatory and India has several commitments. And then how do we link sustainability with the Sustainable Development Goals and blue economy paradigms? And these are the questions. And Honorable Judge, the one particular issue to start with is defining the right of the traditional fishers in India, especially when you think about development. And many of them are coastal inhabitants, and at the same time, all the developmental pressures are on the coastal areas. And if you look at India, almost half of the coastal areas, especially sandy beaches, are eroded, primarily because of the developmental activities and also the climate change and the related activities. And at the same time, for a tribal community, you have their forest right and they have the right to live in the land. At the same time, this is not specifically defined for the traditional fisher communities, where all the kind of developmental pressures are in the coastal areas, and then when there is sea erosion, and they will be shifted to a place which is totally unrelated to them, and they find it very difficult to sustain their livelihood there. And then whether the question here is whether they are considered as ecosystem people, especially when you think about integrated coastal zone development. And we have the integrated coastal and coastal regulation zone notification, which also, and the upcoming integrated coastal development plan, where there is an option, technological option for marine spatial planning, which defines specific areas for development. And even in that case, what my demand is, especially I'm speaking specifically about some of the legal limitations here. And when we speak about marine spatial planning and defining the, the land holding of the fisherman, and that is not done. Even in the marine spatial planning, defining the livelihood and the settlement of the traditional fisherman is not properly done, and that is one of the limitations as far as I look at the integrated coastal zone developmental programs. And second is how, when we speak about sustainability, we speak about economic development, social development, and environmental development, and we never speak about the ethical and ethical angle for that, or the philosophical angle for that. At the same time, when you go through the definition of the World Bank on blue economy, it is actually the sustainability of ensuring the marine fishery resources as well. So that is the theme in which we need to discuss the sustainability issues. And second issue definitely is the upcoming developmental activities, especially overcapitalization which is happening in the marine fishery sector, and the right of the traditional fishermen here. And then you know that majority of the larger fishing vessels are now owned by the people who are supposed to be rich. And at the same time, many of the people who once owned boats became the laborers here. And also there is large number of migration happening in the fishery sector, and which also make the whole issue complicated. At the same time, the government of India is now redefining the deep sea fishing policy, and the deep sea fishing policy, deep sea fishing vessels are also coming to Indian coastal waters for fishing. And then the problem is, how do we actually limit the fishermen, as in the earlier days, where 12 nautical mile is considered as a limitation for the traditional fishermen to fish. And even now, despite the fact that over the last 3 decades, the technology has changed. Many of the fishermen use Chinese outboard engines. They go up to 50 kilometers from the coastal area for fishing. At the same time, the National Marine Fishing Regulation Acts define the 12 nautical mile as the fishing, as the area where the traditional fishers have to fish. And that kind of disparity is still there. At the same time, we are opening up the areas outside the territorial waters to all the deep sea fishing vessels, which are so modern with all the facilities for processing and also export of these. So totally export-oriented facilities, which definitely deny the access to for the traditional fishers to fish in the coastal waters beyond the territorial waters as well. And this is one of the issues definitely we need to address, primarily redefining the fishing areas of the traditional fishermen in the upcoming marine fishing regulation modifications, as well as in the fishing policy. And second issue is something related with a ship accident here in Kerala, and also the compensation filed by the government of Kerala in these issues. And there is MSC Elsa, a ship accident happened in Kerala coastal waters. And then, because there are large quantity of chemicals, hazardous chemicals contained in that. And then, you know, fortunately there was no massive leak, but the leakage was primarily of the plastic nurdles which were contained, tons of plastic nurdles. And even now, if you go to Vinyam, the tourist village, every day now it is coming up, the plastic nurdles are coming up, and primarily the government's duty is to clean up that. And then almost 30 days of fishing days were lost because of the fear of contamination. And then the government consolidated every aspect and filed and there were some other public legal litigations as well in this category. And the compensation claimed by the government was around 9,500 plus crores. And now, interestingly, the company come up with a very serious observation that it did not happen in the territorial waters of India, one. And second, there is no proof for any kind of ecological damage or the livelihood issues connected with that. And then they are now demanding, quoting the international regulations, the claim should be limited to 150 crores. 150 crores. Here the issue is that neither there is any compensation for the traditional fishermen due to the ship accident here, a contamination here, nor there is actually a mismatch between international regulations concerning the compensation here and the national regulations, which we need to discuss thoroughly, because unless and until our national legislations remain intact with the international regulations available in the in pollution mitigation and compensation, and this will not work, and unfortunately we are not going to get any kind of benefit as a result of ecological damages caused by these issues. That is another issue. And now, another issue, now we are always discussing about the USA and the tariff, additional tariff. And the problem which we never discussed is already there is a ban of shrimp export from India. And the reason is that Indian fishing vessels are not using any kind of bycatch reduction devices. It's called primarily turtle excluder device. For example, just for the awareness of many of the people sitting here without a fisheries background, and when you fish using a trawl net, you are intending shrimp, but the shrimp catch will be around 20%. 80% will be non-targeted organisms, and these non-targeted organisms are called bycatch. And in all these kind of fishing in the tropical waters, of course, this technology was developed by Norway primarily to ship in the cooler waters, where the biodiversity is very less. But when you fish in the tropical waters, and the amount of non-target species is very high. And the demand, as per the American environmental protection regulations and the concerned legal instruments, is that India is not using turtle excluder device or bycatch reduction devices, and which increases the mortality of the sea turtles, and therefore we are actually stopping the import of shrimps from Indian waters. And now the scenario is that we are actually expanding the fishing grounds, and the international regulations govern many of the Indian export business as well. And the problem is that we are in the Marine Fishing Regulation Act, it is not mandatory that this kind of bycatch reduction devices are fitted with the modern fishing gears. So that kind of again disparity cause considerable amount of economic loss for India, primarily when we look at the export of marine products. And another point which I need to discuss is again the right for the people to live in the coastal areas, fisher communities to live in the coastal area. We have the Forest Protection Act and the tribe, which actually support many of the tribal community to stay within the ecosystem and the use the resources. At the same time, when you have the issue of climate change and the sea erosion along the Indian coast, and the people who are actually settled in for a longer period of time, basically they're all, all the genetic studies in India shows that, many of the fisher communities, traditional fisher communities living in India, in Indian coast are all earlier tribal people in some way or other. Anyway, but they settle here, and when there is climate change and there is sea erosion, and there is no way of compensating them, there's only a question of replacing them. So whether they will be considered as ecosystem people in all these kind of environmental developmental programs is something which we need to seriously address, and a habitat for them to survive for a longer period of time. And then another point is regarding the pollution. Plastic pollution is a very serious issue in all the marine environment. And based on one of our studies, the National Green Tribunal has taken a suo motu case against the government of Kerala. And I was put in a lot of pressure because it's actually our research which ultimately led the Green Tribunal to take a suo motu case against the Pollution Control Board and the Environment Department here. And this is actually a case of microplastic pollution in the Ashtamudi Lake. And the issue is that, now our study also confirmed that many of the fish which are farmed in the system carry microplastic within the muscle, within the liver, within the brain. So that means the contamination level of the microplastics which passes through the blood vessels and get into the systems of the animal is also very common in the system. And then the government said that, this process will be controlled by the upregulation or, the regulation of the solid waste which actually entering from the coastal areas into the oceans. But there is no monitoring mechanisms. And also in Indian law, one probably a lacuna is the integration of extended producer responsibility into the system, and also the circular economy principles into the system. And both are in principle, the regulations are in the process of development, and unless and until there is some kind of extended producer responsibility upon the companies which actually pollute the system, there is not going to be a permanent solution to the whole issue of marine pollution in general. And finally, my final point will be something connected with another developmental activities which is happening in Kerala coast. This is also a tricky thing as far as legal issues are concerned. For example, now the government main plan is to go ahead for sea mining. And sea mining is primarily for sand mining at the beginning and later for the metallic particles. Okay. And then the area selected for the sand mining in Kerala coast is actually the area where the highest fishing happens in Kerala. And the question here is that, again, technically this is a bit away from the territorial waters, 12 nautical mile area. At the same time, this is an area where all the major fishing activity happens in the Kollam district of India. And there are large number of now litigations filed against that. But then again, there is a disparity between the right of the state and right of the union government in that. And finally, I conclude with another very serious issue about the legal limitations in handling the endangered species. And many times the fishermen were arrested primarily because they keep ambergris. Ambergris, one of the, a material which is higher in demand. This is a product from the whale. When the whales die, particularly when the sperm whale dies, and this material, which is in the intestine, it floats in the water. And then that is a material which is highly priced than the gold in the international market because that is used for making perfumes. And ambergris, when the fishermen take it and use it, and then they will be put in the jail because the animal is in Schedule 1 of the Wildlife Protection Act. And even handling is a major serious issue, and there are large number of issues. And also there is, technically, it's very difficult to prove that the material is ambergris or not because we need advanced chemical treatment for that. And in many of the states, that facility is not available, and that is an issue. And yesterday, I was hearing, a few days back, I was hearing another issue, arrested the fishermen, primarily because they caught sharks. But unfortunately, all the sharks are not in the Wildlife Protection Act, Schedule 1, but only few. But any shark they catch, they will be put in the jail primarily because, or the cases are registered against them primarily because there is nobody who can actually precisely identify what the shark species is and whether they are in the Schedule 1 of the Wildlife Protection Act. And there is again the problem is with the regulatory framework which actually look into the biodiversity aspect of that. And once these are addressed, I am sure that many of the developmental activities need to be sustainable, and we need to bring in the fourth element in sustainability, and that is the ethical element. Thank you so much.
Thank you very much. A big hand for sir. Now we are entering into the speakers compartment. I have 4 forceful speakers, and as we all know, the forceful speakers have the inherent ability to deliver their speech within the time. 6 minutes allocated for each speaker, and I take the privilege to invite first in the speakers compartment Dr. Professor H.J.F. Silva, sir, Vice President, CLEA, as announced earlier, senior most member in the CLEA family. Sir, you have 6 minutes, sir. Thank you very much.
Good morning, Honorable Attorney General and distinguished panelists on the podium, distinguished delegates, visitors and students. The theme today is focused on indigenous people, fisherfolk, and the legal issues. Now, my short presentation is on the indigenous people, especially indigenous people or the Adivasis of Sri Lanka, because my roots are in that country. I was to pick up a thread from yesterday's presentation by the Honorable Attorney General. He said that the word indigenous is given understood in a different context by the Western world. He said to them, they went and occupied other people's land and pushed or marginalized these people and pushed them into reservations and called them indigenous. I'm subject to correction, sir. But where India is concerned, there are no such indigenous people. They are all the same. I was wondering whether we could apply the same interpretation as the Honorable Attorney General said to my home country, Sri Lanka. But you look at Sri Lanka, it looks like that the Western construct fits better, because the majority communities in Sri Lanka all migrants who came from India. Now we have recorded history of more than 2,500 years, which is called Mahavansa, the Great Chronicle. Of course, the events are in that are not fact-checked, but they are pointers as to what happened sometime back in history. Now, it says the original people came from India, Vangadesha, or I think present-day Bengal. So according to that story, that there was this king who had a good-for-nothing son, who went about ravaging villages and doing various horrible things. So the people caught him, and then he wanted to be punished with death. So the king didn't want to do it. So what they did was put him into a boat and put it adrift. And it came to Sri Lanka. When they came to Sri Lanka, they found these indigenous people. So these are pointers that migration took place. When the migration took place, there were people already living there. Now these are the people, today they say the descendants of these people are called Vedas, or the Adivasis of Sri Lanka. However, due to migration, mostly from perhaps Kerala and Tamil Nadu, they are marginalized. They are confined to small areas called Dambana, and there have been a lot of research done about these people, going back to colonial times, starting with a British surgeon during colonial times by the name of Spittal, who researched into their language, customs, beliefs, and this research is still going. I'm subject to correction by my Sri Lankan colleagues, and it's still being done by the University of Peradeniya and Colombo, I think. The research is going on. So, but today, despite that, due to development projects and education, now the culture is getting eroded. There are a lot of intermarriages, so there are hardly any indigenous people, but there are still a few, and mostly they are tourist attractions. They perform their rituals and dances just to attract the tourists. Apart from that, there isn't a major community as Vedas as such. But still, some of them resort to their practices. And then I want to highlight one particular case about a young Veda youth married, according to their customs, a girl of 15 years. In Sri Lankan law, the age of consent is 16. So even though the girl gave her consent, it was statutory rape. And he was prosecuted in courts for statutory rape and convicted and sent to prison. And there was a big outcry against it, but that was the law. But I was wondering, without any offense to anybody, if this youth happened to be a Muslim, what would have been the position? In Sri Lankan law, there is no minimum age for marriage of Muslim women. Even a Muslim judge called Qazi can give permission to even a girl under the age of 12 years. So there is a big conflict between the general law and this particular special law. So how do you reconcile these two? And also, there are the provisions in the Sri Lankan constitution, then international conventions like CRA, Convention of the Rights of the Child, CEDAW, ICCPR, a very host of conventions. So how do you reconcile these two? If you are going to recognize these various customs and also our international obligations, so it would be a fine balancing act. How do we do that? It is up to the legal scholars to find the solution. As Roscoe Pound said, that when there's a conflict, there must be a fine balance. So unless this balance is there, it is difficult to adhere to some of these practices, like the child marriages and also international obligations. So, okay. I won't take much time, but what I have to point out is the problem with regard. So why are we going to preserve them, these people, as mere tourist exhibits? Or are we going to give them education, give them employment, and all that, but at the same time, then you are destroying their culture, their way of life, because they were originally hunter-gatherers. No, I don't think anyone, except a few, must be doing that maybe as for leisure. So it's a question of fine-tuning, balancing the conflicting interests. Thank you very much.
Thank you very much, sir. As I said, the most senior member in our fraternity, I take the privilege to invite Mr. Raman Rajamannan, Tribal King, Kerala's Mannan community. Mr. Raman takes the freedom to speak in Malayalam. We gladly agree. Thank you, sir. Come in.
വേദിയിലും സദസ്സിലുമുള്ള ബഹുമാന്യരെ, പട്ടികവർഗ സമൂഹത്തെ പ്രതിനിധീകരിച്ച് എത്തിച്ചേർന്നിരിക്കുന്ന പ്രിയപ്പെട്ടവരെ, മത്സ്യബന്ധന പ്രതിനിധികളെ, ജനവിഭാഗത്തെ പ്രതിനിധീകരിച്ച് എത്തിച്ചേർന്നിരിക്കുന്ന പ്രിയപ്പെട്ടവരെ, എല്ലാവർക്കും എൻ്റെ വിനീതമായ നമസ്കാരം. പട്ടികവർഗ ജനവിഭാഗത്തെ പ്രതിനിധീകരിച്ച് സംസാരിക്കുവാൻ എനിക്ക് അവസരം നൽകിയ കോമൺവെൽത്ത് ലീഗൽ എഡ്യൂക്കേഷൻ അസോസിയേഷനും അതോടൊപ്പം തന്നെ കേരള ലോ അക്കാഡമി ലോ കോളേജിനും എൻ്റെ എല്ലാവിധ ആദരവും സ്നേഹവും അറിയിക്കുന്നു. നമ്മുടെ പട്ടികവർഗ വികസന വകുപ്പ് നമ്മുടെ കേരളത്തിൽ രൂപീകൃതമായി 50 വർഷം തികയുന്ന ഈ ഒരു കാലയളവിൽ ഈ സമൂഹത്തിൻ്റെ വികസനത്തെക്കുറിച്ചും നിയമ സംരക്ഷണത്തെക്കുറിച്ചുമെല്ലാം സംസാരിക്കുന്നതിനും അതിനെക്കുറിച്ച് ചർച്ച ചെയ്യുന്നതിനുമായി ഇങ്ങനെ ഒരു വേദി സംഘടിപ്പിച്ചതിൽ അതേ സന്തോഷമുണ്ട്. കാരണം ഈ 50 വർഷത്തോളം പട്ടികവർഗ വികസന വകുപ്പ് കേരളത്തിൽ നമ്മുടെ ഇടയിൽ പ്രവർത്തിക്കുന്നുവെങ്കിലും പട്ടികവർഗ ജനസമൂഹത്തിന് 50% വികസനം ക്ഷേമം ഉറപ്പാക്കിയിട്ടുണ്ടോ നടപ്പിലാക്കിയിട്ടുണ്ടോ എന്നുള്ളത് വളരെ ചോദ്യചിഹ്നമായ ഒരു വിഷയമാണ്. ആ തലത്തിൽ ഈ സമൂഹം ഇപ്പോഴും വിദ്യാസമ്പന്നരല്ലാതെ അല്ലെങ്കിൽ വികസന പാതയിലേക്ക് എത്താതെ കഴിയുന്ന ഒരു സാഹചര്യമുണ്ട്. അതിന് മാറ്റം വരേണ്ട കാലഘട്ടവും അതിക്രമിച്ചിരിക്കുന്നു. അതിനായി നമ്മുടെ കേരളത്തിലെ ഭരണകൂടവും അതുപോലെ തന്നെ നീതിന്യായ വ്യവസ്ഥയെല്ലാം അകമഴിഞ്ഞ് ഇടപെടേണ്ട ഒരു കാലഘട്ടവും അതിക്രമിച്ചിരിക്കുകയാണ്. അപ്പം ഈ സമൂഹത്തിൽ അടിസ്ഥാന സൗകര്യം എന്നുള്ളത് ഇന്നും ഒരു എന്താ പറയുക, നമുക്ക് ലഭ്യമാകാത്ത ഒരു ഘടകം തന്നെയാണ്. അതെല്ലാം ലഭ്യമാക്കുവാനായിട്ട് ഒരുപാട് നിയമസംരക്ഷണവും നിയമങ്ങളെല്ലാം നമ്മുടെ രാജ്യത്തുണ്ട്. പ്രത്യേകിച്ച് 2006 വനവാസ നിയമം തന്നെ ഈ പട്ടികവർഗ സമൂഹത്തിന് ഒരുപാട് അവകാശങ്ങളും നേട്ടങ്ങളും ലഭ്യമാക്കാനുള്ള ഒരു നിയമമാണ്. പക്ഷേ അത് നമ്മുടെ കേരളത്തിൽ ഇന്നും ഇംപ്ലിമെൻറ്റ് ചെയ്യപ്പെടാതെ തന്നെ അല്ലെങ്കിൽ അത് നടപ്പിലാക്കാതെ തന്നെ അടിച്ചമർത്തപ്പെട്ട് കിടക്കുന്ന ഒരു നിയമമാണ്. അപ്പോൾ അത് ഈ ഒരു ചർച്ചകളിൽ നമുക്ക് ഊന്നി പറയേണ്ട ഒരു വിഷയമാണ്. ആ ഒരു നിയമം കൃത്യമായി വേണ്ടവണ്ണം നടപ്പിലാക്കിയാൽ തന്നെ പട്ടികവർഗ സമൂഹത്തിനിടയിൽ വലിയൊരു മാറ്റമുണ്ടാകും. അതോടൊപ്പം ഈ സമൂഹം നേരിടുന്ന വേറൊരു പ്രശ്നം, പ്രത്യേകിച്ച് ഇടുക്കി, പത്തനംതിട്ട, വയനാട് ഇങ്ങനെയെല്ലാം ഉള്ള മിക്ക ജില്ലകളിലും ഈ സമൂഹങ്ങൾ നേരിടുന്നത് വലിയൊരു പ്രശ്നം തന്നെയാണ്, ഭൂമിയുമായി ബന്ധപ്പെട്ട പ്രശ്നം. ആ ഒരു വിഷയം എന്നുള്ളത് ആദിവാസികളുടെ ഇടയിലുള്ള അല്ലെങ്കിൽ ആദിവാസികളുടെ കയ്യിലുള്ള ഭൂമികളെല്ലാം മറ്റിതര ജനവിഭാഗങ്ങൾ പല രീതിയിലും അവരുടെ കൈവശമാക്കുകയും അതിലൂടെ അവരുടെ നേട്ടങ്ങൾക്ക് വേണ്ടി വിനിയോഗിക്കുകയും ചെയ്യുന്നതല്ലാതെ ഈ സമൂഹത്തിനായിട്ട് അതിനെ വിനിയോഗിക്കാനായിട്ട് സാധിക്കാറില്ല. അതുകൊണ്ട് തന്നെ ദാരിദ്ര്യത്തിൽ നിന്നും വീണ്ടും ദാരിദ്ര്യത്തിലേക്ക് പോകുന്ന ഒരു സാഹചര്യം ഈ സമൂഹം നേരിടുന്നുണ്ട്. മാത്രമല്ല ആ ഒരു വിഷയത്തിൽ നമ്മുടെ ഭരണകൂടം പോലും മറ്റിതര ജനവിഭാഗത്തിന് വേണ്ടി തന്നെയാണ് നിലകൊള്ളുന്നതും പ്രവർത്തിക്കുന്നതും. നമ്മുടെ ഈ ഒരു വിഷയത്തെ ആസ്പദമാക്കി നമ്മൾ ഗവൺമെൻറ്റിനെയോ അല്ലെങ്കിൽ മറ്റിതര സംവിധാനങ്ങളെയോ നമ്മൾ ആശ്രയിക്കുമ്പോൾ അവരെല്ലാം നമുക്കെതിരെ അല്ലെങ്കിൽ നമുക്ക് ഈ ഒരു ജനസമൂഹത്തിന് പുറംതിരിഞ്ഞ് നിൽക്കുന്ന ഒരു സാഹചര്യമുണ്ട്. അപ്പോൾ ആ ഒരു വിഷയത്തെ ഊന്നി നിലവിൽ ഞാൻ തന്നെ കഴിഞ്ഞ വർഷം നമ്മുടെ ബഹുമാനപ്പെട്ട ഹൈക്കോടതിയിൽ ഒരു കേസ് ഫയൽ ചെയ്തിട്ടുണ്ട്. അത് നിലവിൽ ഹിയറിങ്ങിലെല്ലാം ആവുന്നു. അപ്പം അങ്ങനെ നമ്മുടെ ഏത് തരത്തിൽ അടിച്ചമർത്താമോ ആ തലത്തിലെല്ലാം അടിച്ചമർത്തുവാനും ഭരണകൂടങ്ങളും എല്ലാ രാഷ്ട്രീയ പ്രസ്ഥാനങ്ങളും ശ്രമിക്കാറുണ്ട്. അതിനൊരു കടിഞ്ഞാനിടേണ്ട കാലഘട്ടമായിരിക്കുകയാണെന്ന് ഈ ഒരു അവസരത്തിൽ ഞാൻ ഓർമ്മപ്പെടുത്തുകയാണ്. അതോടൊപ്പം നമുക്കറിയാം ഈ സമൂഹത്തിനെ വികസന പാതയിലേക്ക് അല്ലെങ്കിൽ പുരോഗമന പാതയിലേക്ക് എത്തിക്കാനായിട്ട് ഒരുപാട് അവസരങ്ങളും സാധ്യതകളുമുണ്ട്. അതിലൊന്നാണ് സ്വയം തൊഴിൽ പദ്ധതികൾ അല്ലെങ്കിൽ ട്രൈബൽ ടൂറിസം. ഇങ്ങനെ ഒരുപാട് അല്ലെങ്കിൽ ഡിപ്പാർട്ട്മെൻറ്റിൽ തന്നെ ഒരുപാട് സാധ്യതകളുണ്ട്. ആ സാധ്യതകളെല്ലാം നടപ്പിലാക്കാനുള്ള ഒരു വ്യക്തമായ ഒരു ഡിപ്പാർട്ട്മെൻറ്റിൻ്റെ അഭാവമുണ്ട്. അതായത് ഈ പല ഡിപ്പാർട്ട്മെൻറ്റുകളും നമുക്കറിയാം, ഒരുപാട് മന്ത്രി തുടങ്ങി ലോക്കൽ വരെ ഒരുപാട് ഓഫീസുകളും പ്രതിനിധികളും ഓഫീസ് സ്റ്റാഫുകളെല്ലാം ഉണ്ടാകും. പക്ഷേ ഈ ഒരു പട്ടികവർഗ വികസന വകുപ്പിൽ മാത്രം മന്ത്രി, ഡയറക്ടർ, പിന്നെ ജില്ലാതല ഓഫീസ് ഇങ്ങനെയെല്ലാം ഉള്ള മാത്രം ഒരു 4 ഘടകം മാത്രമുള്ള ഒരു ഡിപ്പാർട്ട്മെൻറ്റാണ്. അങ്ങനെയെല്ലാം ഉള്ള ഒരുപാട് അപാകതകൾ ഈ ഡിപ്പാർട്ട്മെൻറ്റുമായി ബന്ധപ്പെട്ടിട്ടുണ്ട്. അതെല്ലാം നമുക്ക് പരിഹരിക്കേണ്ടതുണ്ട്. ജനങ്ങളുടെ ഇടയിലേക്ക് കടന്നു പോകാൻ പാകത്തിനുള്ള ഒരു വ്യക്തമായ ഡിപ്പാർട്ട്മെൻറ്റായിട്ട് ഈ പട്ടികവർഗ വികസന വകുപ്പ് ആവേണ്ടതുണ്ട്. അങ്ങനെ വിവിധമാർന്ന വിഷയങ്ങൾ നേരിടുന്ന ഒരു സമൂഹം, ആ സമൂഹത്തെ ഉദ്ധരിക്കാനായി അല്ലെങ്കിൽ ഞങ്ങളെ ഉദ്ധരിക്കാനായി നിങ്ങൾ ഏവരും തന്നെ തയ്യാറാകുന്നതിൽ അതിയായ സന്തോഷം. അങ്ങനെ ആവട്ടെ. അതിനുവേണ്ടി കേരള ലീഗൽ സർവീസ് സൊസൈറ്റിയുടെയും അതോടൊപ്പം മറ്റിതര നിയമവ്യവസ്ഥയുടെ എല്ലാം പരിരക്ഷകളുള്ളതാണ്. എങ്കിലും അത് നമ്മുടെ ഇടയിലേക്ക് കുറച്ചും കൂടെ നല്ല രീതിയിൽ കടന്നു വരേണ്ടതുണ്ട്. അതിന് സാധ്യമാവട്ടെ എന്ന് മാത്രം ആശിച്ചുകൊണ്ട് പ്രാർത്ഥിച്ചുകൊണ്ട് ഈ അവസരം നൽകിയ എല്ലാവർക്കും ഒരിക്കൽ കൂടി എല്ലാവിധ ആദരവും സ്നേഹവും അറിയിച്ചുകൊണ്ട് നിർത്തുന്നു. നന്ദി, നമസ്കാരം.
Just on time. Thank you very much, sir. May I now invite Mr. Charles George, State President. He's the President of Fishermen Workers Union. Mr. Charles also requests liberty to speak in Malayalam. Sir, please, you have 6 minutes. Sir.
പ്രിയമുള്ളവരെ, ഞങ്ങൾ ജീവിക്കുന്നത് ചെകുത്താനും കടലിനും ഇടയിലാണ്. ബിറ്റ്വീൻ സ്കില്ല ആൻഡ് കാരിബഡി വി ആർ ലിവിങ്. ഇപ്പോഴത്തെ അവസ്ഥ അതാണ്. ഇന്നത്തെ പത്രം എടുത്ത് നോക്കി നിങ്ങൾ, മനോരമ ഫ്രണ്ട് പേജിലെ വാർത്ത എന്താണ്? കേരള തീരത്ത് ആണവ നിലയം കൊണ്ടുവരാൻ തീരുമാനിച്ചിരിക്കുകയാണ്. സ്മോൾ ആൻഡ് മോഡുലർ റിയാക്ടർ കൊണ്ടുവരാൻ തീരുമാനിച്ചിരിക്കുകയാണ്. 10,000 മെഗാവാട്ട് വൈദ്യുതി. അത് സ്ഥാപിക്കുന്നത് ചീമേനിയിലാകാം, കായംകുളത്താകാം, അല്ലെങ്കിൽ കൊല്ലത്താകാം. കടപ്പുറത്താണ് വരുന്നത്. നമ്മൾ എന്ത് പഠിച്ചു? ഫുക്കുഷിമയിൽ നമ്മളെന്ത് പഠിച്ചു? ചെർണോബിൽ നമ്മളെന്ത് പഠിച്ചു? 3 മൈൽ ഐലൻഡിൽ നമ്മളെന്ത് പഠിച്ചു? ഒരു ചുക്കും പഠിച്ചില്ല. അതാണ് നമ്മൾ പറയുന്നത്. പ്രത്യേക ഇടതുപക്ഷമാണ് ഭരിക്കുന്നത്, ഓർക്കണം. തൽക്കാലത്തെ എക്സ്റ്റെൻഡ് ചെയ്യുന്നത്, പക്ഷേ അതിൻ്റെ പ്രവർത്തനം നടന്നുകൊണ്ടിരിക്കുകയാണ്. ഇതാണ് നമ്മുടെ അവസ്ഥ. ഈ ഡെവലപ്മെൻറ്റ് വിത്ത് ഹ്യൂമൻ ഫേസ്, ഓൾ ഇൻക്ലൂസീവ് ഡെവലപ്മെൻറ്റ്, ഇറ്റ്സ് നല്ല വാചകങ്ങളാണ്. അതൊക്കെ നല്ല ഫ്രെയിം ചെയ്ത് വയ്ക്കാവുന്ന വാചകം മാത്രമാണ്. ഞങ്ങൾക്കത് ബാധകമല്ല, മത്സ്യമേഖലയ്ക്ക് പ്രത്യേകിച്ച്. പിന്നെ വരുന്നത്, ഞങ്ങൾ ജീവിക്കുന്നത് ഇക്കോ സിസ്റ്റം വിപ്ലവമാണ്. ഇക്കോളജിക്ക് വലിയ മാറ്റം ഉണ്ടായിട്ടുണ്ട്. പണ്ടൊന്നും കേരളത്തിൽ ഇങ്ങനെ ആയിരുന്നില്ലല്ലോ. ഇപ്പോൾ ഓക്കിക്ക് ശേഷം വലിയ മാറ്റം വന്നു. ഓക്കിയിൽ കൊച്ചിയിൽ നിന്ന് പോയ തുത്തൂർ ഫിഷർമെൻ്റെ 6 ബോട്ട് അങ്ങനെ തന്നെ മുങ്ങിപ്പോയി. 67 മനുഷ്യർ ഇപ്പോഴും മുങ്ങിക്കിടക്കുകയാണ്. അവർ രക്ഷിക്കുമെന്ന് നിർമ്മല സീതാരാമനും പ്രധാനമന്ത്രിയോടൊന്ന് പറഞ്ഞു. ഒരു രക്ഷയുമില്ല, ഞങ്ങൾക്ക് രക്ഷ ഞങ്ങൾ മാത്രം. ഓക്കിക്ക് ശേഷം ക്യാർ, ഗജ, വായു, നിസർഗ, ഉംഫൻ, ടൗട്ടെ, ഒന്നിന് പിറകെ ഒന്നായി ഇങ്ങനെ കടലാക്രമണമാണ്. കടലാക്രമിക്കുന്നില്ലല്ലോ, കാലാവസ്ഥ വ്യതിയാനമാണ്. അത് കടലിൽ പോകുന്നതിന് മാത്രമല്ല കരയും ബാധിച്ചിട്ടുണ്ട്. കരയും തീർന്നുകൊണ്ടിരിക്കുകയാണ്. ഇതാണ് നമ്മൾ നേരിടുന്നത്. കരയിൽ തീർന്നുകൊണ്ട്. അതിന് മാത്രമല്ല, കരപ്പയിൽ വരുന്ന ആക്രമണം ഉള്ളിൽ നിന്ന് മുകളിൽ നിന്ന് കൂടി വരുന്നില്ല. അത് രാഷ്ട്രീയമായ നയത്തിൻ്റെ പേരിലാണ്. അത് യഥാർത്ഥത്തിൽ വരുന്നത് എന്തിൻ്റെ പേരിലാണ്? ബ്ലൂ ഇക്കോണമിയുടെ പേരിലാണ്. ബ്ലൂ ഇക്കോണമിയുടെ ഭാഗമായിട്ട് വരുന്ന ഈ ആക്രമണം ആർക്ക് തടയാൻ പറ്റിയിട്ടില്ല. നമുക്ക് ലീഗൽ സെല്ല് തടയാൻ പറ്റുന്ന എനിക്ക് തോന്നുന്നില്ല. കാരണം 1994 ഗുന്ദർ പോളി ഐക്യരാഷ്ട്ര സംഘടനയുടെ ആസ്ഥാനത്ത് ബ്ലൂ ഇക്കോണമിയുടെ ആശയം വയ്ക്കുന്നത്. അദ്ദേഹം പറഞ്ഞത് ഈ ഓൾ ഇൻക്ലൂസീവ് ഡെവലപ്മെൻറ്റാണ്. പക്ഷേ അത് നടന്നില്ലല്ലോ. ഇപ്പോൾ ഇന്ത്യ ഗവൺമെൻറ് നമ്മളൊക്കെ പുറത്തിറങ്ങാൻ പാടില്ലാത്ത കാലത്ത്, 2020 ഓക്കിയുടെ ഇതിൻ്റെ കാലത്ത്, രോഗബാധിതമായ കാലത്ത്, 4 ആൾ പോലും കൂടുന്നത് നിരോധിക്കപ്പെട്ടൊരു കാലത്താണ് ബ്ലൂ ഇക്കോണമി ഡോക്യുമെൻ്റ് അംഗീകരിക്കുന്നത്. 607 പേജുണ്ട്. ഒരു മാസത്തിനുള്ളിൽ കേരള ഗവൺമെൻറ് അഭിപ്രായം പറയാൻ പറഞ്ഞു. ആരും പറഞ്ഞില്ല അഭിപ്രായം. 7 ഡോക്യുമെൻറ്റ്സിൽ 607 പേജുണ്ട്. അതിൽ കടലിലെ മത്സ്യബന്ധന അവകാശം അത് നഷ്ടപ്പെട്ടു. ഇന്നലെ കേന്ദ്ര പാർലമെൻറ്റ് ഒരു കമ്മിറ്റി പാസ്സാക്കിയ നിയമം വെച്ചിട്ടുണ്ട്. ഞാനതിന് മറുപടിയും കൊടുത്തിട്ടുണ്ട്. നമ്മുടെ കടലിൽ പുതിയതായി വൻകിട കപ്പലുകളെ കൊണ്ടുവരാൻ തീരുമാനിച്ചിരിക്കുകയാണ്. 1977 ചാർട്ടേഡ് വെസൽസ് വന്നു, 82 ചാർട്ടേഡ് വെസൽസ് വന്നു, 91 ന്യൂ ഡീപ് സീ ഫിഷിംഗ് പോളിസി വന്നു, 2014 മീനാകുമാരി വന്നു. ഇതെല്ലാം പരാജയപ്പെട്ടു പോയില്ലേ? കാരണം നമ്മുടെ മത്സ്യത്തിൻ്റെ വെറും 4% മാത്രം ആഴക്കടലുള്ളത്. ഇത് പിടിക്കാൻ വലിയ രീതിയിൽ ചിലവ് വരുമല്ലോ. അത് കാരണം ഇന്ത്യയിലെ ടാറ്റയും ITCയും ഡള്ളപ്പും പോലുള്ള കമ്പനികൾ, പുതിയ കമ്പനികൾ ഫ്ലോട്ട് ചെയ്തവർ, ഇൻഡോ ഫിഷറീസ്, ഇൻഡോച്ചം ഫിഷറീസ്, ഫോർച്യൂൺ ഫിഷറീസ്, അവരൊക്കെ നട്ടത്തിലവിടെ കെട്ടിപ്പൊട്ടി വീട്ടിൽ വെച്ചു. പൊളിഞ്ഞു പോയ പരിപാടിയാണ്. അതാണ് വീണ്ടും ഗവൺമെൻറ് തീരുമാനിക്കുന്നത്. ഇതിൽ ചർച്ച ഞാൻ പങ്കെടുത്താണ് കേന്ദ്ര ഗവൺമെൻറ്. അതിൽ പറഞ്ഞത് 100 ബോട്ടുള്ള ഗുജറാത്തിലെ ഫിഷർമെൻ ലീഡറല്ല മുതലാളി, അയാൾ 10 പേരെ ചേർത്തൊരു കോപ്പറേറ്റീവ് ഉണ്ടാക്കും. ഞാൻ പറഞ്ഞു ഇത് കോപ്പറേറ്റീവുകൾക്ക് കൊടുക്കണം. മുരാരി കമ്മിറ്റി പറഞ്ഞാണ്, യു ഹാവ് ടു കോപ്പറേറ്റൈസ് ട്രഡീഷണൽ ഫിഷ് വർക്കേഴ്സ്, യു ഹാവ് ടു മോഡേണൈസ് ദം, ദാറ്റ് ഇസ് അവർ ഓൾ മോട്ടോ. അപ്പോൾ അത് അംഗീകരിച്ചു. പക്ഷേ അപ്പോൾ പറഞ്ഞു ഞങ്ങൾ കോപ്പറേറ്റീവുകൾക്ക് കൊടുക്കും. ആർക്കാണ്? വൻകിടക്കാരുടെ കപ്പൽ സമൂഹം വരാൻ പോകുന്നു. ഇന്ത്യയിൽ 3,14,577 യാനങ്ങളുണ്ട്. ലോകത്ത് ഏറ്റവും കൂടുതൽ യാനങ്ങൾ ക്യാൻവസുള്ള ഇന്ത്യ രാജ്യത്ത് മാത്രമാണ്. ഇതിനകത്ത് 10-40 ലക്ഷം മത്സ്യങ്ങളും മീൻ പിടിക്കുന്നുണ്ട്. നമുക്ക് വേണ്ടത് വെറും 93,000 യാനങ്ങളാണ്. അതിൻ്റെ 3 ഇരട്ടി പത്തനം ഉണ്ട്. പിന്നെ എവിടെ പോകും നമ്മൾ? ആ സമയത്താണ് കടലിൽ വൻകിട കപ്പലുകളിൽ കൂടി കൊണ്ടുവരുന്നത്. ഞങ്ങളൊക്കെ കൂടി ആലോചിച്ച് ശക്തമായ ചെറുത്തിൽപ്പന ആലോചിക്കുകയാണ്. അതൊരു വിഷയം. ഇതൊന്ന്. 2, നമ്മുടെ കടൽ തീരം നഷ്ടപ്പെടുകയാണ്. കേരളത്തിൻ്റെ പ്ലേസർ മിനറൽസ്, അതായത് കരിമണൽ, അത് കേന്ദ്ര ഗവൺമെൻറ് ഏറ്റെടുക്കുകയാണ്. അത് ആർക്ക് കൊടുക്കും? കുത്തകൾക്ക് കൊടുക്കാൻ തീരുമാനിച്ചു. കടൽ മണൽ, നേരത്തെ ബിജുകുമാർ പറഞ്ഞില്ലേ, അത് സ്റ്റഡി നടത്തിയിട്ടുണ്ട്. കടൽ മണൽ അത് ആർക്ക് കൊടുക്കുന്നു? കേന്ദ്ര. അത് ഞങ്ങളുടെ പ്രതിഷേധം കാരണം നിർത്തണോ? 7 തവണ മാറ്റി വെച്ചു ടെൻഡർ. അവസാനം ഇപ്പോഴും ആരും വന്നിട്ടില്ല. ഞങ്ങളുടെ വിഷയം കാരണം വരാത്തതാണ്. അതാണ് ഞങ്ങളുടെ വിഷയം. ഞങ്ങൾക്ക് ജീവിക്കണമെങ്കിൽ സമരം ചെയ്യണം. അത് കടൽ മണൽ, അതിനുമപ്പുറത്ത് ക്രസ്റ്റുകളുണ്ട്, പോളിമെറ്റാലിക് നോഡ്യൂൾസ് ഉണ്ട്, പോളിമെറ്റാലിക് സൾഫൈഡ്സ് ഉണ്ട്. ഇതൊക്കെ വലിയ സമ്പത്താണ് അവർ കാണുന്നത്. അത് പിടിക്കാൻ വേണ്ടി വൻകിടക്കാരെ മാത്രം ഏൽപ്പിക്കുന്നവർ പ്രഖ്യാപിച്ചിരിക്കുകയാണ്. ഇത് കടലിലെ കാര്യം. കടപ്പുറത്തെന്നാണ് അവസ്ഥ അറിയാമോ? കേരളത്തിൽ ഇപ്പോൾ വിഴിഞ്ഞം വന്നില്ലേ? വിഴിഞ്ഞത്തിൻ്റെ അവസ്ഥ നിങ്ങൾക്ക് അറിയാമല്ലോ. വിഴിഞ്ഞം മാത്രമല്ല, ജഖാർ ഗുജറാത്ത്, പിന്നെ മഹാരാഷ്ട്രയിലൊരു സ്ഥലം, മഹാരാഷ്ട്രയിലും ഒരു സ്ഥലത്തുണ്ട്, കാർവാർ കർണാടക, വിഴിഞ്ഞം കേരള, പള്ളിക്കര തമിഴ്നാട്, സുവർണരേഖ തൊറീസ, താജ്പൂർ കൽക്കട്ടയ്ക്കടുത്ത്. എല്ലാ സംസ്ഥാനവും വ്യത്യസ്ത പാർട്ടികൾ ഭരിക്കുന്നു. ഇവിടെയൊക്കെ തുറമുഖങ്ങൾ വരാൻ പോകുന്നു. ഈ തുറമുഖങ്ങൾ മുഴുവൻ അവകാശി ആരാണ്? നമ്മുടെ പാർട്ട്ണറാണ്. ആരാണ്? അദാനിയാണ്. അവിടെ നടക്കുന്ന പ്രവർത്തനം നിഗൂഢമാണല്ലോ. എൽസാത്തിൽ മുങ്ങിയിട്ട് അതിൻ്റെ കണക്കൊന്നും വന്നിട്ടില്ല ഇപ്പോഴും. അവർ വെളിപ്പെടുത്തിയിട്ടില്ലല്ലോ. എന്തുകൊണ്ട് മുങ്ങിയെന്ന് പറഞ്ഞിട്ടില്ല ഇപ്പോഴും. അതാണ് അവസ്ഥ. ലോകത്തെ അന്താരാഷ്ട്ര മയക്കുമരുന്ന് മാഫിയായിട്ട് ബന്ധപ്പെട്ട ടൈമായി ഓക്കെ ആയിട്ട് ബന്ധപ്പെട്ട സ്ഥാപനം MSC കൂടെ നമ്മൾ അറിയണം. ഇതാണ് നടക്കുന്നത്. അതുകൂടാതെ ഇപ്പോൾ നമ്മുടെ കടൽ പോകുന്നത്, കടപ്പുറം പോകുന്നു, നമ്മളങ്ങോട്ട് പോകും. ഞങ്ങൾ തള്ളി കടലിൻ്റെ അരികിലേക്ക് എത്തി. ഞാൻ അങ്ങോട്ട് പോകും. കടലിലേക്ക് ചാടാൻ നമുക്ക് പറ്റുള്ളൂ. വേറെ വഴിയില്ല നമ്മുടെ മുന്നിൽ. അതാണ് അവസ്ഥ. അതുകൊണ്ട് ഞങ്ങൾക്ക് ചെറുത്തിൽപ്പ് പറ്റുള്ളൂ. അതാണ് നമുക്കിപ്പോൾ. ഞാനൊരു കാര്യം പറയട്ടെ. 2009 ഈ ഗവൺമെൻറ്, കേരള ഗവൺമെൻറ് ഒരു കമ്മിറ്റി വെച്ചു. ഞാൻ ആ കമ്മിറ്റിയിൽ അംഗമാണ്, അക്വയറിംഗ് റിഫോംസ് കമ്മിറ്റി. അതിൽ ഞങ്ങൾ പറഞ്ഞു ഉടമസ്ഥ അവകാശ യാനങ്ങൾ ഇനി അങ്ങോട്ട് മത്സ്യത്തൊഴിലാളികൾക്ക് മാത്രമേ കൊടുക്കുള്ളൂ എന്ന് പറഞ്ഞു. അത് ഇതുവരെ നടപ്പായിട്ടില്ല. അതാണ് നമ്മൾ ശ്രദ്ധിക്കേണ്ട വിഷയം. ആദിവാസി അവകാശമുണ്ട്, അതുപോലെ അവകാശം കേരളത്തിൽ വരേണ്ടതുണ്ട്. ഇതൊക്കെ എനിക്ക് പറയാനുള്ളത്. മാത്രമല്ല CRZ ഞാൻ കേസ് കൊടുത്താണ് ഈ മുത്തൂറ്റിൻ്റെ 357 കോടിയുടെ നിക്ഷേപം പൊളിച്ചു കളയാൻ കേരള ഗവൺമെൻറ്, കേരള ഹൈക്കോടതി ഡിസിഷൻ എടുത്തത്. പിന്നെ സുപ്രീം കോടതി അംഗീകരിച്ചു. പക്ഷേ അതിനുശേഷം ഇൻ്റർലോക്യൂട്ടറി ആപ്ലിക്കേഷൻ, സ്പെഷ്യൽ ലീവ് പെറ്റീഷൻ, എന്തൊക്കെ കാര്യങ്ങളെന്നറിയില്ല, 7 ദിവസം നീണ്ടുപോയി. അവസാനം ഇപ്പോൾ അത് പൊളിച്ചിരിക്കുകയാണ്. അപ്പോൾ കടലിനെ രക്ഷിക്കാൻ, കടപ്പുറത്ത് രക്ഷിക്കാൻ ഒരു മഹത്തായ പ്രസ്ഥാനം ഉണ്ടായേ പറ്റൂ. അത് ഞങ്ങളുടെ മാത്രം വിഷയമല്ല, അത് കേരളത്തിൻ്റെ മൊത്തം വിഷയമാണ്. കേരളം ഒന്ന് ചൊട്ടക്കെട്ടായി അണിനിരക്കണം. ഡു ഓർ ഡൈ എന്ന സിറ്റുവേഷൻ നമ്മൾ നിൽക്കുന്നത്. അതുകൊണ്ട് കടപ്പുറം രക്ഷിക്കാൻ, കടൽ രക്ഷിക്കാൻ, മത്സ്യത്തെ രക്ഷിക്കാൻ, മത്സ്യത്തൊഴിലാളികളെ രക്ഷിക്കാൻ നമുക്ക് ഒന്നിച്ചൊറ്റക്കെട്ടായി മുന്നേറാമെന്ന് മാത്രം പറഞ്ഞുകൊണ്ട് ഞാൻ അവസാനിപ്പിക്കുന്നു. അഭ്യർത്ഥിക്കുന്നു.
Thank you very much, Mr. Charles George. This is my privilege to invite Dr. Manjusha K.A., Assistant Professor, School of Gandhian Thought and Development Studies, MJ University. Madam.
Respected dignitaries on and of the dais, faculties and friends, a very warm good morning to one and all of you. Today I'm not going to be a speaker, I'm going to be a reader because of the restriction on time. So I am speaking on the identity, law and recognition of the indigenous tribal communities in Kerala, and it is indeed a great privilege for me to stand before you to represent the indigenous tribal communities in Kerala. So as most of you know, we have already 36 tribal communities, including 5 particularly vulnerable tribal communities, and most of you know, despite the Kerala's progressive image, the tribal communities has here continued to struggle with land alienation, cultural marginalization, and denial of rights. And coming to the identity of the indigenous tribal people in Kerala, it's not simply a matter of census categories or scheduled tribe lists. It is a living identity deeply tied to land, forests, and rivers and cultural practices. So the communities such as the Irula, Muduga, Kurumba, and the Paniya, all these communities, they have unique ways of the life rooted in subsistence farming, shifting cultivation, herbal medicine, oral traditions, and community-based governance. And their languages, songs, oral traditions, rituals, and ecological practices embody a worldview which is where the human beings, animals, and forests are already interdependent. And however, the identity of these tribal peoples are under constant threat. With the spread of the settler colonialism during the last century, large tracts of Adivasi land were taken over for the plantations, dams, and forest reserves. For instance, in Attapadi, tribal land ownership fell from nearly 90% in the 1950s to less than 20% by the 1990s. With the loss of land came the loss of the food diversity, autonomy, and cultural continuity. In the mainstream society, Adivasis are often portrayed as the backward or the primitive, which diminishes their sense of self and denies their right to self-definition. Identity for them is not just about being recognized as scheduled tribes, but being respected as the communities with knowledge systems, dignity, and sovereignty. And second aspect is the law, and in principle, India's constitution and state legislations provide significant safeguards for the scheduled tribes. But in practice, there are wide or deep gaps. Historically, the colonial policies, like the Madras Forest Act in 1882, restricted the tribal access to forests. This legacy continued after independence with development projects displacing communities without adequate rehabilitation. And to counter this, Kerala government introduced the Kerala Scheduled Tribes Restriction on the Transfer of Lands and Restoration of the Alienated Lands Act of 1975. And its purpose was to restore the alienated tribal lands, but the law was never effectively implemented. Later amendments in 1990s weakened this restorative spirit, making the land restoration nearly impossible. At the national level, the Constitution provides safeguards through many articles which directs the states to protect the scheduled tribes from social injustice and exploitation. Reservation in education and employment has also created some opportunities. I am not denying the facts. The most transformative legal instrument in recent times has been the Forest Rights Act 2006, which recognized both individual and community forest rights. However, in Kerala, the implementation has been slow and contested. Many claims have been rejected on technical grounds, and community forest rights are still largely pending. The judiciary too has often been ambivalent, sometimes upholding the settlers' claims over the indigenous people's rights. Thus, while laws exist in paper, their execution frequently reflects the interests of the dominant groups rather than the Adivasi communities. Coming to the recognition, which is the third aspect of this session, firstly, there is the need for the land rights recognition. Without the secure access to their land and forests, Adivasi communities cannot sustain their identity, economy, or culture. Implementing the Forest Act sincerely and restoring the alienated land is crucial. Secondly, the cultural recognition is necessary. This means valuing the tribal languages, literatures, and ecological knowledge systems. Our education curricula must include the indigenous histories and knowledge, not just the mainstream perspectives. Community-led cultural initiatives such as the documenting songs, rituals, and oral histories need state support. Thirdly, the recognition must extend to the social and economic roles of the Adivasi women. In many communities, women are the guardians of the seed preservation, herbal medicine, and caregiving. Yet the development policies rarely acknowledge their contributions, focusing instead on men and external experts. Fourth, there is a need for political recognition. Adivasi voices are still marginal in decision-making spaces. While there are constitutional provisions for the representation, in practice, their participation in local self-governance is minimal. Strengthening the Adivasi councils, such as the Urukutams, is very important. So recognition is therefore not about token gestures. It means respecting indigenous worldview, self-determination, allowing these communities to decide the course of their development. To conclude, indigenous tribal people of Kerala are profound identity rooted in land and culture. While the laws exist to protect them, they are often poorly implemented or diluted. And recognition of their rights, contributions, and knowledge systems remain incomplete. For Kerala, to truly uphold its image of social justice, it must go beyond welfare schemes and token acknowledgements. It must restore land, strengthen laws, and recognize the dignity and sovereignty of Adivasi communities. In the words of many tribal movements across Kerala, land is life. Without land, their identity fades. Without legal recognition, their struggles intensify. And without recognition, their future remains uncertain. Indigenous communities in Kerala, not confined to high ranges alone, this is the most important point, they also inhabit in in the plains and coastal regions. The issues they encounter and the needs they articulate vary significantly across these diverse ecological and social landscapes. Consequently, the uniform implementation of the single legal framework fails to address their heterogeneous realities and undermines the effectiveness of the state interventions. What is required, therefore, are region-specific policies that are sensitive to local context and responsive to the differentiated aspirations of the tribal communities. Thank you. Thank you so much.
Thank you very much, Dr. Manjusha. Now we are entering into the discussions compartment. We have valuable discussions here. May I humbly request to conclude your speech in 2.5 minutes, please. I take the privilege to invite Professor Dr. Rose Vijay Shekhara, Head of the Department of Private and Comparative Law, Faculty of Law, University of Colombo, Sri Lanka, ma'am.
Thank you very much, Honorable Chair and the members of the panel, and ladies and gentlemen, very good morning to you. I'll be very brief, and thank you very much for giving me this opportunity to share my thoughts about the very appropriate theme. But permit me to change the words a little bit, to shift the wording, to focus on, to pose you a question on the role of the law in identifying and recognizing indigenous tribals and fisherfolk. The role of the law. Now, from yesterday and even today, Honorable Attorney General expressed his dissent over the division between modernity and indigeneity, or the wording. But my question to you is, who created this division? What was the role of the law in creating this division between modernity and indigeneity? So, despite global acceptance of the rights of indigenous people, we know that they are rarely given legislative recognition. However, the judiciary has recognized the rights of indigenous groups and fisherfolk to their identity and representation. Now, who create these legal minds? Who create the law people? Who create their minds? Who inculcate the identities? Who inculcate the value systems? And who inculcate the policies, principles, and legal norms which we preserve and protect as pristine? Where have we received the law? And what is the law that we Indians, Sri Lankans, Bangladeshis have been governing ourselves? Who is responsible? So the theme is very, very relevant to Sri Lanka as well, where the population statistics confirm 0.5% of other ethnic groups, meaning that the island is home to a small percentage of indigenous groups. Now, who are these other? Who is the and who is the other? Who created this division? So being an island nation, the country is enriched by fisher folk who contribute immensely to the economy and cultural diversity. Sorry. Let me just highlight three indigenous groups in Sri Lanka, that is the Veddas or the Adivasis, whom Dr. Silva highlighted, and the Mukwar community, who is a Tamil-speaking ethnic group found in the western and eastern coast, who have migrated to Sri Lanka from Kerala, and the Telugu group, who is, even though small, represents again the Kerala culture and tradition, but they are not recognized, their cultures and traditions are not recognized in the mainstream general law that Dr. Silva highlighted. Thank you very much.
Thank you, Professor Rose. I now invite Dr. Preeta S., Associate Professor, School of Legal Studies, COSET. Thank you, ma'am. 2.5 minutes, please.
Respected dignitaries on and off the dais, delegates participants and dear students. I'll be flagging some of my concerns which I have with respect to the implementation of the Forest Rights Act 2006. As you all know, may be knowing, we know that during the pre-colonial era, and the post-colonial era, the forest bureaucracy has been following a template which considered the forest dwellers as encroachers on the forests. So it was with the enactment of the Forest Rights Act 2006 that the forest dwellers and the tribals were recognized as the custodians of the forest resources. So in fact, this is a very landmark legislation which provides a bundle of rights in terms of habitation, development, and community rights. But when it comes to the enforcement, we find that from what we can gather from a very report which was made by the Kerala government, the implementation of the act has been uneven, mainly because of the difficulties in establishing the forest rights and the community rights. And the report says that only 60% of the potential forest rights have so far been granted. And this is a report which was published by the Kerala government itself. And we also find many cases of fake claims being made and fraudulent dispositions being made in this regard. I would like to draw your attention to a specific case that is Moolangangal hamlet in Attapadi. And the land records of the hamlet, it reveals a very disturbing pattern of illegal transfers and encroachments. We find that the titles have been given to non-tribal communities, non-Adivasis, and also in the name of non-profit trusts. And these non-tribal groups, they have fenced off large portions of the land, blocking the tribal access to their critical resources. And it has cut off the pathways to the river and also the community rights which they have with respect to a temple which is nearby. So we find that the very implementation has resulted in a negation of the rights of the tribal community. There is large-scale clearing using heavy machinery like bulldozers. So this again is a clear violation of the forest rights granted under the FRA Act. So I would like to conclude by saying that a concerted effort is required from the part of advocacy groups, civil society groups, and also the bureaucracy, and again the judiciary also, for recognizing the rights, for supporting their rights, and to make sure that the legal recognition that is granted under the FRA is translated into actual possession and protection of the forest rights of the tribals and the indigenous communities. Thank you.
Thank you, Dr. Preeta. May I now invite Dr. Aunita Epothil, Associate Professor of Law, Ramaya College of Law, Bengaluru, and Joint Secretary, CLEA, Asia. I will not announce her time. She already assured me.
Sure, sir, I'll do that. Greetings of the day to all dignitaries on and off the dais. In the given stipulated time, I would like to mainly highlight on 4 important pathways to protect and enhance the recognition of tribal community as well as the fisher folks. Coming to the first one, I would like to mainly highlight about the community resource rights framework, which is the need of the hour. As rightly said by my former speakers, similar to the Forest Rights Act of 2006, the need of the hour is the fisher folks' rights, whether it might be protecting of the individual rights as well as the community rights, is the need of the hour. Looking into the lessons or the best practices elsewhere also, I think Philippines also has been based on the same coastal resource management, which is also made as statutory. It would also be in conformity with the ILO Convention 169 and the UN Declaration of the Rights of the Indigenous Rights. And also one important focus point is here is the informed consent. So here, as rightly said by the former speakers, that Gram Sabhas are not to be symbolic forums, but also has to be decisive institutions for the social sector when it comes to local self-governance. Second point, I would also like to focus on the institutional Gram Sabha for the coastal zones, whether it might be making them a statutory consultative and give them a veto powers for protecting their coastal zones, especially with regard to the modified coastal zones. And coming to the best practices, I think already we have been hearing this since yesterday, that the child also has a similar participatory mechanisms across the globe. Coming to the third pathway, it would be the integrated fishery governance and the mechanisms, like making sure the multi-stakeholders like fisheries, environmental shippings, and port authority should not work in silos, but has to go in hand. I think, again, we can say the best lessons which we can take, or the lessons which we can learn from the best practices across the globe would be the Australian concept of the Great Barrier Marine Park. Here, I would also like to focus on the downtown, compliance, where it might be an oriental approach, where we can say community autonomy has to be given along with the state authority, which is the need of the hour. The last one, I think that is the major focus of my point today, because I come from an academia, and I want to say that this is the role where how academia can mainly play a vital role here, that is through legal literacy and mainly with clinical legal educations. So here, with regard to two points, I would also take yesterday's point, which mainly was focused, is the curriculum. So here, the law schools have an important role to play as to how they can integrate curriculum modules with regard to marine resources and the coastal ecology, as well as the students of LSE, Legal Service Authority, as well as the legal service clinics of all the law schools can mainly, give the legal aid with regard to, framing certain handbooks in the respective regional languages. They can also assist the fishermen with regard to any sort of grievances, or it might be training, community participations, and environmental clearances can be mainly assisted by the students' body with regard to the legal service clinics, which is run by the law schools. I think with this, I would like to conclude. Thank you so much for your patience hearing.
Thank you, Anita. I now invite doctoral scholar, ILI, and convener CLEA, Ms. Nabila Jahra. Nabila.
A very good morning to everyone. Before I begin my presentation, I would just briefly like to mention that I come from a landlocked state where there's not even a single river or even a natural lake. But a few years ago, we did try to create an artificial lake, and we did introduce a few fishes, but it was very difficult for them to survive in an environment that was completely different from theirs. And so we're still dependent upon the fisherfolk communities from a region that is geographically different from ours. And the problems that the fisherfolk communities are facing, it is not only a matter of concern for them, but for us as well. And when it comes to natural disasters or even pollution, it is them who are the first responders, the first victims who are facing these. So when we talk about creating a framework for them, and I think this point has already been raised by the learned Attorney General, that we should not only follow the Western framework, but rather we should also recognize and give them voices when it comes to lawmaking. Apart from that, I also feel that the state must support capacity building in these communities, and which includes the documentation and revitalization of the customs, languages, and traditional knowledge. And we also need to introduce legal literacy and access to justice and enhance so that when it comes to the rights, they can voice their rights effectively. So the commitment to protect and uplift the indigenous and fisherfolk rights is a foundation to a truly inclusive and just democracy. Thank you.
In the discussions panel, the last discussion, Mr. Barun Dab. May I invite you, sir, Assistant Professor, Kerala Law Academy, Law College.
Respected Chair, Co-Chair, distinguished delegates, colleagues, and friends. It is both an honor and a responsibility to present before you today the outcome of two pilot studies conducted under the banner of Center for Advanced Legal Studies, which is the research facility of Kerala Law Academy, in collaboration with CLEA. Our first study, Margins at the Shorelines, focused on the fishing villages adjoining the Vizhinjam International Port. The findings were sobering, that it shows that declining fish catches and erosion were visibly undermining traditional livelihoods. Weak awareness of CRC norms and compensation rights left communities vulnerable. Women vendors, in particular, reported increased cost and shrinking access to landing centers were also being found. And our second study, Contours of Indigenous Justice, turned inland to the Kani tribal settlements of the Agasthyamala biosphere, in which the finding revealed that many forest rights claims remain rejected despite community testimonies. Restricted access to forest produce threatens both livelihood and cultural practices. Women and youth face increased insecurity as younger generations drift away from traditional knowledge system. So what do these pilot studies tells us? That law as it exists today is often right on paper but not justice in practice. Communities at the coast and in forests remain at the margin of legal enforcement. But these pilots are not to the end. They are beginnings. Building on them, Culture proposes a longitudinal research program 2025-26 that will conduct a GIS-based shoreline regression mapping and link it with socio-economic vulnerability indices in coastal villages. Then it also undertake comparative studies of indigenous justice framework, connecting Kerala's Kani experience with the Veda community of Sri Lanka. Draft two model frameworks, a coastal livelihood protection framework and a model indigenous justice framework, and develop a legal education module on tribal and fisherfolk rights so that the classroom become an incubator for community justice. The justification for this transition is simple. Pilot studies have shown us gaps. Future research must fill them. Friends, CLEA 2025 offers us a platform to move from evidence to empowerment. The shores we map and the forests we walk through remind us that sustainability cannot survive without subsistence, and that law must listen as much as its legislators. Let us therefore commit ourselves to a jurisprudence that protect, empower, and sustain. This is the vision that culture places before you today. Thank you.
Thank you very much. So the speaking and the discussion part is over. May I now invite Ms. Shiva Verghese, Senior Assistant Professor. 1 minute? 1 minute. Sir, the Chair, Learned Attorney General for India and Patron CLEA, sir, your final remark on the session you just chaired.
I don't want to hold your attention for long, but we had emotionally involved presentations, and presentations which made us sit back and think about why we have not thought about these things. That's the beauty of this kind of engagements and deliberations. But what happens today is, let me just flag the essence of our discussion yesterday and today. The traditional access to resources of life, one framework, which all civilizations have evolved over a period of time. And within those broader civilizational frameworks, there are subsets of civilizations. So traditional way of looking at how human beings will relate to nature in order to make a life and livelihood out of their engagement with nature. When you move away from one framework to another framework, then we have problems. So we are in the process of understanding the shift to a new framework where all those conventional, traditional understanding of relationships are under huge stress, strain, and therefore challenge. And then connected to all this, when we talk about framework of life, we talk about culture, we talk about an understanding of interrelationships, and then faith, religion, so on and so forth. They form the other set of packages of life. And then we talk of cultural marginalization. It is not only for one set of people, all of us, I think, belong to any faith or religion, or in the process of losing our control over our cultural resources. So therefore, when we shift the legal framework or the economic and other framework, shifts all these other victims. So there is no disconnection between them, they are so connected. So we look at it therefore holistically and say how therefore we want to talk about either arresting moving completely into one framework where everything will be destroyed, or you need to therefore strike a balance, and who will strike a balance? Who did what is the question, right? Therefore, who can do what, and in what manner will be the best question to be asked. Therefore, we must provide for who all can do what, and in what manner. If a constitutional and legal framework can provide for who all can do and do what, I think we would have probably moved into a more, participatory governance and democracy. Thank you so much.
As a token of our respect and gratitude, we would now like to felicitate our distinguished dignitaries and participants. I request Dr. R. Venkataramani, Learned Attorney General for India and Patron CLEA, and Professor Dr. S. Shivakumar, President CLEA, to felicitate Honorable Mr. Justice Apresh K. Singh, Chief Justice, High Court of Telangana, Professor Dr. A. Biju Kumar, Vice Chancellor, Kufos, Kochi, Dr. H.J.F. Silva, Vice President, CLEA, UK. Mr. Raman Rajamanan, Tribal King, Kerala's Mannan Community. Mr. Charles George, State President, Kerala Matsya Tolil Ekyavedi. Dr. Manjusha K.A., Assistant Professor, School of Gandhian Thought and Developmental Studies, MG University. Professor Dr. Rose Vijayskera, Head of Department of Private and Comparative Law, Faculty of Law, University of Colombo, Sri Lanka. Dr. Preeta S., Associate Professor, School of Legal Studies, QSAT. Dr. Anita Patil, Associate Professor of Law, Ramaya College of Law, Bangalore, and Joint Secretary, CLEA, Asia. Ms. Nabila Zehra, Doctoral Scholar, Indian Law Institute and Convener, CLEA. Mr. Varun Dev S., Assistant Professor, Kerala Law Academy, Law College. Mr. Prashant Barwa, Barrister, UK, Secretary, CLEA, Bangladesh. Mrs. Sheba Varghese, Senior Assistant Professor, St. Dominic's College of Law, Kanjirapalli, Kottayam. Mr. Rajiv SS, Advocate, Thiruvananthapuram and Executive Member, CLEA, India.
Thank you all.
Thank you, everyone. For successful delivery, participation, and engagement. May I now invite Mrs. Sheba Varghese, Senior Assistant Professor, St. Dominic's College of Law, Kottayam. Ma'am.
Thank you, sir. Honorable Chair, respected co-chair, distinguished speakers, esteemed delegates, and dear participants. This session has truly been a collective of ideas, perceptives, and lived experience on the theme Indigenous Tribals, Fisherfolk, Identity, Law, and Recognition. It is my proud privilege to propose the vote of thanks. First and foremost, I extend my heartfelt gratitude to our chair, Dr. R. Venkataramani, learned Attorney General for India and Patron CLEA, for gracing this session with his esteemed presence and for sharing valuable insights that have set the tone for our deliberations. Thank you, sir. A special thanks to the co-chair, Honorable Mr. Justice Apresh K. Singh, Chief Justice, High Court of Telangana, for his gracious presence and valuable perceptives. Thank you, sir. And we are equally grateful to Professor Dr. A. Bijukumar, Vice Chancellor, CUFOS, Kochi, for the thought-provoking team presentation that shed light on sustainable and traditional livelihoods. Thank you, sir. Our sincere thanks to our eminent speakers, Dr. H.J.F. Silva, Vice President CLEA UK, then Sir Sri Raman Rajamanan, Tribal King of Kerala's Manan community, Mr. Charles Jose, State President, Kerala Malsitholali Aikyavedi, and Dr. Manjusha K.A., Assistant Professor, School of Gandhian Thought and Development Studies, Mahatma Gandhi University, for their scholarly and practical contributions to his important conversation. Thank you all. My sincere thanks to all the discussions which enriched the discussion immensely. Thank you, all the discussants. Then I also wish to acknowledge the effort of our moderator, Mr. Prashant Barwa, Barrister UK and Secretary CLEA, Bangladesh, for conducting this session seamlessly and ensuring engaging interactions. Thank you, sir. Finally, I extend heartfelt thanks to all the participants, reporters, and the organizing team whose presence and contributions have made this session truly meaningful. On behalf of the Commonwealth Legal Education Association and the Kerala Law Academy Law College, I once again express my gratitude to each one of you for joining us in this dialogue that strengthens our commitment to justice, identity, and sustainability. Thank you, and let us continue to work together for a more inclusive and sustainable future. Thank you.
Thank you all. May I kindly request everyone to proceed for the tea reception area towards your right. We will join back in 10 minutes for our next session, as Justice Vibhu Bhakru, for the chair of our session, is already, co-chair of our session is already here, and Justice K.V. Vishwanathan will be joining us in another 5 minutes. So I would request everyone to join us promptly after the tea. Thank you all.
whose traditions are as old as the land itself. For centuries, the tribes of Kerala have carried forward a way of life that celebrates simplicity, spirituality, and the rhythms of earth. Their homes, crafted from bamboo, leaves, and clay, stand as living symbols of sustainable living. Every tool, every ritual, every melody is drawn from the forest around them, blending human existence seamlessly with nature's bounty. Step into their world and you will find festivals alive with color and rhythm. Dances performed around the fire, the steady beat of drums and chants that echo through the valleys, and each ritual tells us a story, not just of faith, but of a community's bond with the earth. The tribal attire, adorned with beads, feathers, and vibrant fabrics, reflects not only beauty but also deep cultural meaning. The tribes of Kerala are also skilled artisans. They craft bamboo baskets, wooden sculptures, and intricate ornaments that carry the essence of their identity. Each piece is not just an object, but a story of patience, creativity, and connection with the natural world. But what truly makes Kerala's tribal culture remarkable is the philosophy behind it. A respect for nature that goes beyond survival. They do not just live in the forest, they belong to it. Every festival, every prayer, and every tradition is a reminder that human life is sacred only when it honors the earth. For the traveler seeking more than just sights and sounds, Kerala's tribal heritage offers a journey into authenticity. Kerala invites you to experience this living heritage, a world where culture is not displayed but living every day. From the Paniyas of Wayanad to the Kurumbas of Attapadi, each community carries a way of life that is rooted in nature and tradition. Yet, resilience defines these communities. In recent years, self-help groups, cooperatives, and government programs have helped improve their livelihoods. Tribal youth are increasingly entering universities and public service, carrying forward their identity while seeking justice within the framework of law. The story of Kerala's tribal people is one of both continuity and change. Their culture embodies centuries of wisdom, but their future depends on how society ensures equality, dignity, and protection of rights. Recognizing their struggles and honoring their heritage is not charity, but it is a responsibility. For in their survival lies the survival of our collective roots and the harmony between human beings and nature. Kerala opens its heart to you. Come experience the warmth of its people, the purity of its forest, and the timeless spirits of its tribe. Here every smile is genuine, every rhythm is sacred, and every moment is a celebration of life itself. When you walk away, you do not just carry memories. You carry stories, emotions, and an unspoken connection with a way of life that is rare and precious in today's world. This is Kerala, not just God's own country, but the keeper of ancient wisdom, waiting to share its soul with you. Deep in the lush forests of Kerala, nature hides a golden treasure, that is wild honey. Collected by traditional honey gatherers from the hives of giant rock peas, this honey carries the purity of untouched wilderness.
വനത്തിൽ നിന്ന് ശേഖരിച്ചു കൊണ്ടുവരുന്ന പച്ചമരുന്നുകളും തേൻ സാധനങ്ങൾ ശേഖരിക്കുന്ന സ്ഥലമാണ് BSS കെട്ടിടമാണ്. ആളുകൾ ചരക്കെടുക്കാൻ പോകുന്നത് മലയിലേക്കാണ്. അത് കുടുംബമായിട്ടും ഒറ്റയ്ക്കും പിന്നെ 2-3 പേർ വച്ചാണ് പോകുന്നത്.
For centuries, honey hunters have ventured into the towering cliffs and dense woods, guided by tradition and courage to collect this rare nectar from the hives of giant rock bees. Every drop of this honey carries the story of the land, the fragrance of blooming forest flowers, the essence of rare medicinal herbs, and the delicate harmony of peace with their surroundings. It is a taste shaped by the rhythm of the wild. Once gathered, the honey is gently filtered and processed, ensuring that its raw purity is never lost. From hive to bottle, this journey is as authentic as the forests themselves. Kerala's wild honey is not just food, it is medicine, tradition, and living gift from the wild. Balaramapuram, a small town near Thiruvananthapuram, is world renowned for its traditional handloom weaving. With roots tracing back to the royal patronage of Maharaja Balaramarama in the 18th century, This weaving tradition is a living heritage of Kerala. Woven on simple looms by skilled artisans, Balaramapuram fabrics are celebrated for their purity, softness, and intricate golden zari borders.
ആദ്യം താരാണ് ചുറ്റി പഠിച്ചത്. താഴെ ചുറ്റി പഠിച്ചിട്ട് പിന്നീട് അത് 2-3 വർഷമൊക്കെ പഠിച്ചാലേ ഇത് പഠിക്കാൻ പറ്റുള്ളൂ. ഫസ്റ്റ് നമ്മൾ നെയ്ത് കുറച്ച് നെയ്തിട്ട് താഴെ വെക്കുന്നത്. ഇത് ഈ ഓടത്തിൽ വെച്ച് അടച്ച് മുമ്പ് ആകുമ്പോഴേ ഇത് പറ്റുള്ളൂ. ഈ വരുമാനം ഒരു അടിയൊക്കെ 265 രൂപ. ഇത് നല്ല പാടുള്ള തൊഴിലാണ്.
Handlooms here is not just a craft, it is the livelihood of entire families. Today, Balaramapuram handloom has earned global recognition, standing as a timeless symbol of Kerala's textile tradition. Hidden within Kerala's emerald forests and rolling hills lies a world untouched by time, the vibrant culture of its tribal communities. These are the people who live in harmony with nature, whose traditions are as old as the land itself. For centuries, the tribes of Kerala have carried forward a way of life that celebrates simplicity, spirituality, and the rhythms of earth. Their homes, crafted from bamboo, leaves, and clay, stand as living symbols of sustainable living. Every tool, every ritual, every melody is drawn from the forest around them, blending human existence seamlessly with nature's bounty. Step into their world and you will find festivals alive with color and rhythm. Dances performed around the fire, the steady beat of drums and chants that echo through the valleys, and each ritual tells us a story, not just of faith, but of a community's bond with the earth. The tribal attire adorned with beads, feathers,
May I have your kind attention, please? Our honorable dignitaries have arrived. May I request everyone to please promptly join in another 2 minutes, please. No.
Only this much I want to say no for the vote of thanks. K. Vishwanath, Bakru, C.T. Arvind is not there.
No, he's not.
So, the other one, Binumol, Kokila ma'am.
Binumol, where is he?
She's a welcome address. Okay.
May I have your kind attention, please? I request all of you to please be seated. Kindly take your seats. I request all of you to give a warm and respectful welcome to the Chair and Co-Chair of the session, Honorable Mr. Justice K.V. Vishwanathan, Judge, Supreme Court of India, and Honorable Mr. Justice Vibhu Bakru, Chief Justice, High Court of Karnataka, as they take their seat at the dais. I also request the speakers, Honorable Mr. Justice Sam Koshe, Judge, High Court of Telangana, Honorable Mr. Justice D.K. Singh, Judge, High Court of Karnataka, Mr. Prashant Barua, Barrister, UK Secretary, CLEA, Bangladesh, Dr. Jacob Joseph, Professor of Law and Associate Dean, Savita School of Law, Chennai, Dr. Belu Shekhar, Chair, Professor of Criminology, Loknayak Jayaprakash Narayan and National Institute of Criminology, Mr. K.R.R. Ayyappa Mani, Advocate and Vice President, CLEA, India, Dr. P. George Giri, Advocate on Record, Supreme Court of India, Ms. Rashmi Aisha, Director and CEO, KIMS Health, Vice President, Telemedicine Society of India, Kerala Chapter, Mr. Salman Kasmi, Doctoral Scholar, Indian Law Institute and Convener, CLEA, Asia. Our moderator for the session, Professor Dr. Kokila, and Dr. Dakshina Saraswati, Associate Professor, Kerala Law Academy and Chief Conference Coordinator. I request our moderator for the session, Professor Dr. Kokila Korasinge, to take over the sessions. Thank you so much.
Aibowan, may you live long in good health and happiness. And Namaskaram. Today, I think, is marking a remarkable achievement of CLEA when we conclude this wonderful gathering of vibrant ideas and way forward. Let me begin the plenary session 3, and the theme of this session is Custom, Law and Sustainable Ecosystems, Legal Models for the Future. And we have our respected chair and co-chair, and also we have 4 speakers and 5 discussants. So let's start the session with the welcome address by Dr. Binu Mall, Director, School of Legal Studies, Mascot.
Distinguished guests, esteemed members of the judiciary, respected faculty members, and dear students, a warm good morning to one and all. As we are into the second day of this 2-day international seminar, international conference on convergence of sustainability and subsistence, espousing the cause of indigenous tribals and fisherfolk, which is jointly organized by Commonwealth Legal Education Association in partnership with Kerala Law Academy Law College and School of Legal Studies, Cochin University of Science and Technology in Cochin Metro. And coming to the theme for this today's session, it is Custom, Law and Sustainable Ecosystems, Legal Models for the Future. Before getting into this task of rendering the welcome, first I would like to extend a hearty welcome to all the participants to this 2-day international conference, and to throw a few insights on this theme of this conference and this session. It is Custom, Law and Sustainable Ecosystems and Legal Models for the Future. And the focus of this session basically is on adoption of regulatory frameworks converging the interests of the fisher folk and the indigenous communities who place much reliance for their right to livelihood on this coastal waters. And as we know that we have a robust regulatory mechanism which has evolved over years, and the backbone of this regulatory framework definitely is the international norms which are adopted by the UN and International Maritime Organization. And we have other agencies like FAO as well taking care of the protection of fisher folk. And we have been seeing that the UN Convention on Law of the Seas 1958 and 1982 has adequately addressed the state's responsibility in extending protection to the resources of the sea and promoting access to the resources to the fisher folk. And accordingly, and we have the safe guidelines which are adopted under FOU for safe fishing, Code of Safe Fishing adopted by the FAO in 1981. And we have guidelines which have come up to deal with the design, construction, equipment, and manning of fishing vessels as well, which is accommodated into the Indian Merchant Shipping Act 1958. And we know that currently there are attempts from the side of the government as well to streamline the rights of fishers and also for their protection. And we have had an abortive attempt at the behest of central government by floating the Indian Marine Fisheries Bill in 2021. And throughout the discussions, and Mr. Charles, who is the president of Matsya Aikyavedi, will be knowing that we were very hardly pleading for the interests, for securing the interests of fishermen throughout the discussions. Wherein, against the background, I would like to bring your attention to the climate change phenomenon that is happening across the world, which is seriously impacting the fishers as well. As the coastal shoreline is heating up with climate change and ocean warming, many of the fish species which were available in abundance in the coastal waters are now moving towards the deep seas. And there is a great demand from the side of the fishermen to extend their right of exercising fishing from just restricting it to 12 nautical miles. They were demanding for a fishing inside the exclusive economic zone as well, where as Charles was rightly pointing out, they were demanding for constitution of a cooperative framework under which they can also afford highly mechanized vessels to deal with fishing. So in that context, what I want to place before you is that the law is always changing. So we need to accept that change and mold our laws in such a way as to protect the rights of these fishermen and also the indigenous folk and their rights, as we have been doing with CRZ notifications as well. So with that note, I would like to move on to my task of welcoming the esteemed speakers, resource persons for this session. And so here, we are deeply honored by the gracious presence of Honorable Mr. Justice K.V. Vishwanath, Judge, Supreme Court of India. So welcome you, sir. We also have Justice Vibhu Bakru, Chief Justice, High Court of Karnataka, as the court chair for this session. I also extend a hearty welcome to you, sir. Then we also have a galaxy of 4 speakers to share their insights on the theme of this session. And we have Honorable Justice Shyam Koshi, Judge, High Court, Telangana. We extend a cordial invitation to you, sir. We also have Honorable Justice D.K. Singh, Judge, High Court of Karnataka, gracing this occasion. And sir will also be speaking on this theme. Welcome you, sir. We also have Prashanta Barua, barrister, is barrister in UK and Secretary CLEA from Bangladesh. I also extend a warm welcome to you, sir. And we have an academic gloss with a speaker from the academic field. We have Dr. Jacob Joseph, Professor of Law and Associate Dean, Savita School of Law, Chennai. Welcome you, sir. Then we also have an enriched panel of discussants who will bring their valuable insights and experience to this platform. We have Dr. Beulah Shegar, Chair Professor Criminology, Loknayak Jayaprakash Narayan, and National Institute of Criminology and Forensic Sciences. Welcome, ma'am. Then we have Mr. K.R.R. Appannamani, who is an advocate and Vice President of CLEA. Welcome you, sir. Then we have Dr. George Giri, Advocate on Record, Supreme Court of India. Welcome, sir. Then we have Reshmi Aisha, who is the Director and CEO, KIMS Health. Welcome, ma'am. And finally, we have Salman Basmi, who is the Doctoral Scholar of Indian Law Institute and Convener CLEA. Welcome, sir. So with this, it is great pleasure that once again I want to welcome all of you to this esteemed gathering, and we can look forward to very insightful discussions and deliberations throughout this session. Thank you.
Thank you, Dr. Binu. Now, to opening the session, may I very respectfully invite Honorable Justice K.V. Vishwanathan, Judge, Supreme Court of India.
Thank you, Dr. Kokila. Distinguished Attorney General for India, Mr. R. Venkatramani, Chief Justice of the High Court of Karnataka, my distinguished brother, Justice Bibu Bakru, Justice Jayashankar Nambia, Senior Judge of the Kerala High Court, distinguished dignitaries on the dais and off the dais, both from India and abroad, Professor Dr. Shivkumar, ladies and gentlemen, a very good morning to you. At the outset, let me congratulate CLEA for organizing this seminar on the overarching topic of convergence of sustainability and subsistence, espousing the cause of indigenous tribals and fishermen, and the subtopic for the present session, custom, law, and sustainable ecosystems, the legal models. The welcome address, you have been given an overview of the legal regime. What I propose to do is briefly touch upon what perhaps the legal model should provide for. We'll briefly see the existing scenario. We'll touch upon the international regime very briefly, and then suggest some ideas so that going forward, these are incorporated in the legal systems. I begin by thanking CLEA and the Kerala Law Academy for carrying forward the spirit of the Kumarakom Declaration, which so clearly affirmed the role of customary law in sustainability. It's a privilege to be part of this dialogue, which brings together experts, the domain experts in this field. Kerala, of course, needs no reminder that communities are often the best custodians of resilience. In 2018, when the floods came, it was our fishermen who turned their country boats into lifelines. We'll also touch upon the movie dealt with it as we go forward in the speech. The world called them the Kerala Navy, but to the people rescued, they were simply saviors, neighbors who knew the waters better than anyone else. The act of courage and community is perhaps the finest metaphor for today's theme. For what the fishermen did then is what they have always done: protect lives by protecting their waters. The practices that put food on the table, selective harvesting, seasonal pauses, shared access are also the practices that sustain ecosystems for generations. These are not casual habits, but structured systems of governance, passed down with the rhythm of the tides. The Kumarakom Declaration reminded us of the simple truth that sustainability and subsistence are not opposing ends, but a shared horizon. And in this, these practices echo the spirit of the global community's own commitments, whether it is Sustainable Development Goal 14, life below water, or Sustainable Development Goal 15, life on the land.
But what gives a custom its strength? Customary practices to be recognized in law must have 4 attributes. It's been taught to us from our college days: antiquity, continuity, reasonableness, and certainty. These qualities explain why they have endured across centuries, because they are time-tested, ecologically sound, and socially legitimate. In India, we find powerful illustrations of this kind. The Kadakodi Fisher Councils of Kerala function as democratic assemblies, deciding on fishing norms with remarkable effectiveness. The Padu lottery system at the Pulicat Lake allocates fishing grounds fairly among families. In Meghalaya, sacred groves are preserved through unwritten rules that protect biodiversity better than many statutes. From the statutory side, Kerala's Marine Fishing Regulation Act of 1980 deserves mention. It reserves near shore waters for artisanal fishers and enforces a monsoon trawling ban, both measures drawn from ecological wisdom embedded in custom. The lesson here is that law and custom, when aligned, reinforce one another and strengthen sustainable ecosystems. Courts too have recognized this convergence. In Samatha, the Supreme Court safeguarded tribal lands in Andhra Pradesh from mining leases, affirming the constitutional protections. In Niyamagiri case, it upheld the authority of the Grama Sabha, allowing tribal communities to decide the fate of their sacred hills. In Jagannath, intensive shrimp farming was banned because it destroyed certain ecological and undermined local livelihoods. More recently, the Manipur High Court intervened to halt evictions of traditional fishers from the Loktak Lake. Across the world, we find similar affirmations. In Australia, the Mabo decision overturned the fiction of terra nullius, that is, land that is legally deemed to be unoccupied or uninhabited is nobody's land. This was done away with, recognizing Aboriginal native title. And if you see any Australian function, whether it's the court swearing in, whether it's any inauguration, they pay a tribute to their Aboriginals, and that's how the function begins. In New Zealand, the Whanganui River was granted legal personhood, embedding Maori cosmology into law. The Torres Strait Islanders in Australia convinced the UN that climate harm is cultural harm. Yet, the story of the mosquito divers in Honduras, who secured recognition at the Inter-American Court but continue to suffer due to poor enforcement, reminds us that legal victories must be matched by practical action, otherwise recognition risks become a mere tokenism. Where then do we go from here? There are some clear models. First, recognition and protection must be meaningful. Laws like the Forest Rights Act, the PESA, and the Kerala Marine Fishing Regulation have given formal recognition to community practices, but enforcement remains the real test. Without it, right exists on paper alone. Second, governance must be participatory. Communities must not merely be consulted, they must share decision-making power. Kerala's Kadakodi Fisher Councils and Gram Sabhas in tribal regions already embody this principle. Internationally, Chile's Rapa Nui Marine Park, co-managed by indigenous representatives and state officials, is a strong example of shared governance. Third, law must adopt an ecosystem-centric approach. This means recognizing that ecology, economy, and community are deeply interlinked. In India, the Bishnoi community's protection of wildlife or fisherfolk's traditional monitoring of breeding cycles reflect ecological knowledge that enrich statutory laws. Similarly, community-led mangrove stewardship shows how conservation and livelihoods go hand in hand. 4, education and capacity building are critical. Communities must be equipped with both ecological knowledge and legal literacy. Initiatives such as Barefoot College in Rajasthan, which trains rural women in sustainable technologies, or fisherwomen cooperatives in Gujarat restoring mangroves, demonstrate how empowerment strengthens stewardship. 5th, law must prioritize food security and equity. Finally, flexibility in governance is essential. Fisheries law in Kerala already provides regulatory space for new conservation rules. The vision that emerges is one of legal pluralism, statutory law and customary systems working together in harmony. It's also a vision of intergenerational equity so powerfully captured in Miners Oposa versus Factoran in the Philippines, where children sought to protect forests for generations unborn. For us, it means recognizing that indigenous and fishermen communities are not passive beneficiaries. We have recognized intergenerational equity in the pollution context vis-a-vis humans, the general public, in Vellore Citizen and a long line of cases in the Supreme Court. Kerala's fishermen, rescuers during floods, stewards of the coast stand as a living reminder that resilience lies not only in technology or infrastructure, but in the knowledge and solidarity. Art too has carried the memory forward. The film 2018, Everyone is a Hero, portrayed with striking honesty how fishermen and villagers turned their country boats into arcs of survival. In the end, ultimately, it is a question of coexistence, it is participatory governance, and all this should find recognition in the legal model so that legal enforcement is effective and meaningful. Thank you very much, ladies and gentlemen.
Thank you very much, Justice Vishwanathan, for bringing in so many contemporary developments in rights of nature and lessons learned for best practices. Thank you very much. And next, may I very respectfully invite Honorable Justice Vibhu Bakru, Chief Justice, High Court of Kerala, Karnataka.
Justice K.V. Vishwanathan, the Attorney General of India, Mr. Venkataramani, Justice Nambiar, my all dignitaries on the dais, off the dais, very warm good afternoon, good morning to you. At the outset, I must compliment CLEA and Kerala Law Academy for organizing this conference. It's really a topic that's really burning, and deliberations are essential, to say the least. The ecological preservation was not an ideal lost to the framers of the Constitution. The Indian Constitution enshrines not merely the individual rights, but the collective dignity of communities whose lives, livelihoods, and cultures are woven inseparably with the natural world. The forests of the Adivasis, the rivers of FISHERFOLK, the grazing lands of pastoralists, these are not inert commodities. They are living entities, and for those who depend on them, they are also kin, heritage, and spirituality. The 42nd Amendment to the Indian Constitution, enacted in 1976, marked a significant milestone in this regard. The insertion of Article 48A crystallizes the obligations towards environmental protection and enhancement, reconciling the governing environmental protection statutes, the ideals and provisions under the Constitution of India, considering plurality of society that makes this nation, the duties and ideals envisaged by our framers of our Constitution are not lost but must be viewed as opportunities to address, refine, and implement action for protection of the environment in these challenging times. We must acknowledge at the outset that implementation of laws in a pluralistic society is layered, complex, and often in a fragile balance with individual rights and larger public goods. We are not the only society that grapples with this inherent tension. Theorists such as Charles Tahljoh have recognized such asymmetrical elements to a federalist nation where diversity brings about a difference in states possessing different levels of power and autonomy. In respect to the Indian Constitution, this is borne out by Article 244 and 366 together with the 5th and 6th schedules, which constitutionally accept differentiated governance in scheduled areas in relation to certain subjects. Thus, the Constitution accepts this asymmetry and pluralism. Theorists have recognized that rather than a monotonous interpretation traditionally attuned to constitutionalism, constitutional pluralism accepts the coexistence of multiple legal and normative orders under one constitutional framework. This acceptance of a different normative systems, including statutory law, customary law, international law, and religious law, coexisting, sometimes overlapping, and interacting, is a feature of a pluralistic society. It is in this parallel existence that tensions arise and questions of interpretation of diverse rights pose a challenge for the judiciary and governance. The international recognition of customary rights of indigenous persons has been a subject matter of much debate. The International Labour Organization, ILO, Convention on Indigenous and Tribal Populations Convention 1957, number 107, was the first comprehensive international instrument setting forth the rights of indigenous and tribal populations which emphasize the necessity for protection of social, political, and cultural rights of indigenous people. Following that, there were two other conventions, the ILO Convention 169 and the Indigenous Tribal People Convention 1989, and the United Nations Declarations on Rights of Indigenous People, UNDRIP 2007. India is only signatory to ILO Convention 107. The Constitution via Article 48A and Article 51AG, read with Article 21, 25, and 26, all anchor the ideal of environmental protection. This holistically looked at with guarantees are the Constitution are not divorced from the community-driven ecological stewardship. The provision of the Panchayat extension to the Scheduled Areas Act 1996 PISA was enacted to extend the establishment of panchayats and gram sabhas to scheduled areas, given autonomy to the grassroots level for impacted communities. Section 4 explicitly provides for state legislations on panchayats to be made in consonance with the customary law, social and religious practices, and traditional management practices of community resources. The enactment of the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006, that is FRA, strengthens this parallel normative existence, and as an extension of PISA, the FRA recognizes the customary rights of forest dwellers and the concerned tribe's customary law. It also vests powers with the Gram Sabha for decision impacting forests of which these dwellers were customary habitants. The provisions of FRA are not absolute. They are subject to the overarching recognitions for conservation of wildlife where coexistence would not be otherwise possible. Its provisions are not in derogation of other enactments but supplement them. Thus, considerations under the Wildlife Protection Act 1972 and the Environmental Protection Act 1986 may overlap. In fact, the Wildlife Protection Act under Section 36C recognizes the importance of community reserves, underscoring the need to preserve cultural and ecological landscapes. Even the Biodiversity Act 2002 and the National Forest Policy 1988 also advocate for integrating biodiversity conservation into community-based management frameworks. It is in this light of these customary rights that disputes may arise. There can be no straitjacket formula on how these conflicts with statutes enacted by the central and the state government have to be read. It would but naturally have to be tested with keeping in mind the respective factual matrix. A look at the decisions over the years would serve as a good yardstick to show how these tensions are dealt with. While the decision in Samantha versus State of Andhra Pradesh was seminal in holding and held court, the state government also stands prohibited to transfer by way of lease or any other form known to law the government land in scheduled areas to non-tribal person, be it natural or juristic person, except to its instrumentality or a cooperative society composed solely of tribes. The letter of law would be an empty content and by play of words deflect the course of justice to the tribals and denude them of the socio-economic empowerment and dignity of their person. The decision was foundational, but it was before the FRA. In Orissa Mining Corporation versus Ministry of Environment and Forest, a challenge for a bauxite mining came to be challenged. The conflict therein was between Mines and Minerals Development and Regulation Act and the provisions of PISA and FRA. The court also recognized the religious freedom guaranteed to STs and TFDs under Article 25 and 26 of the Constitution. The above-mentioned articles guaranteed, it said, I'll quote that, the above-mentioned articles guarantee them the right to practice and propagate not only matters of faith or belief, but all those rituals and observations which are regarded as an integral part of their religion. Their right to worship the deity, Niyam Raja, has therefore to be protected and preserved. In this regard, the Gram Sabha was considered primary in such decision-making. The Supreme Court thus called for Gram Sabha to take the decision and communicate the same. Recently, the Supreme Court in T.N. Godavarman, Thiruvananthapuram versus Union of India, has reinforced the need to acknowledge cultural practices the customary for the persons in Rajasthan. The Supreme Court recognized that Orans are related to religious practices followed since time immemorial and serve to conserve natural resources. I needn't read what the court said, but since the time is out, I must conclude by saying that one looks at the decisions all throughout, we find that there is a strong move to ensure that the rights are protected. The challenge, as Justice Vishwanathan said, really lies in implementing them. So I'll leave it at that. Thank you very much.
Thank you very much, Honorable Justice Vibhu Bakru, for that in-depth legal analysis looking at how international customary law and its relevancy to for the development of national legal framework and the indigenous communities legal framework. Thank you very much. And now I think Honorable Justice K.V. Vishwanathan has another official commitment. So thank you very much for joining with us today. Now we are open for the speakers, and each speaker will have 6 minutes each. And let me first invite Mr. Prashant Barua, Barrister UK and Secretary CLEA Bangladesh.
Yeah, it is fine. That will continuously reminds me here, but I shall be brief. I promise. Just I will be actually a storyteller to you, and you will immediately understand how the first generation of climate refugees in the then East Pakistan in 1958 are still suffering. You may have already known that in 1947, Indian flag was hoisted for 1 week in district headquarters of Rangamati. Now the Hill district is split into 3 districts, Rangamati, Khakrachuri, and Bandarban. I'm close to Bandarban. I'm from a coastal town named Cox's Bazar, the near to border town of Burma, now Myanmar, and the biggest refugee camp in the world now. It's hosting nearly, it was initially 12 lakh, now it is 18 lakh. And I was one of the first responders in 2017 when this influx and exodus happened. Oh, so it's very close to me. I'm not exactly from indigenous part, I'm very close to them, and many of my relatives are still there. You see, the customary ownership of land were marked by a century-aged banyan tree. The Chakma, Marma, Tripura, and 12 others indigenous group and subgroups, they are used to enjoy their land right based on the marking of the trees. And after 1971, particularly it started in 1975, the people were ferried there from other districts. I must say, for a religious and population dividend-wise intention driven. I tell you just a statistics on that. Before this ferrying happened from plain districts, the population ratio was 85-15. Indigenous people constituted 85% of total hill population and the 15 from other side. Now it is, in 50 years span of time, it is 53, 47 reverse. So you see how the entire demographic landscape has been shifted into a reverse gear. And the catalyst was, when settlers arrived, they said, what is this banyan tree? We have the dalil given by local land office, 5 acres each per family. And they were effectively guarded and protected by paramilitia, most of them. those paramilitia members were recruited from these families. So the Chakmas, Marmas, Tripuras, they had no option other than fleeing to many neighboring Indian states. That is another tragedy. I just followed a BBC report 2 or 3 years ago. I can't exactly remember. The last community member who fled in 1962 in Arunachal province were given Indian citizenship just 7 days before he passed away. So entire generation carried a legacy of sufferings that started in 1962, actually 1958, when the dam was constructed. So you see, for hoisting Indian flag, probably there are other reasons too, 1 week in the district headquarters of Dangamati was penalized and brutally penalized by submerging the entire livelihood, including the then palace temple of Chakma community. And it is actually, it still remains unnoticed by the literature and the jurisprudence of international climate refugee landscape. It's still, I didn't find that many articles on that, just a few, but written by local. It's still not recognized by the legal system. So the customary law of land was terribly, horrifically overridden by Dalil. So you see, there is a saying, that's my concluding remark, that God made the villages and men made the towns, and towns not recognizing what God made. So recognizing indigenous people is respecting God, goddess. I believe from this podium and this auditorium, the audience will be advocating their voice and lending their voice for those who never allowed to speak. Thank you.
Thank you very much, Mr. Prashant, for that very much, it's full of taste of ethnographic observations and very interesting analysis. Thank you. Next, I would like to invite Dr. Jacob Joseph, Professor of Law and Associate Dean, Savita School of Law, Chennai.
Distinguished dignitaries, honored of the dais, and dear participants. At the outset, let me thank the Commonwealth Legal Education Association for giving me this opportunity to address this august gathering. I would be speaking on the theme Law, Custom, and Sustainable Ecosystems, the Future Legal Models. So let me try to bring some clarity with regard to the theme. I would be specifically focusing on how and whether it is possible for customary practices and the formal legal system to peacefully coexist, and if so, in what respects, and whether it is possible to integrate customary practices into the formal legal systems so as to achieve the objective of sustainable ecosystems, and what future models can be developed in that regard. And I will be addressing this theme specifically keeping in mind the scenario or landscape of Indian fisheries only, not the tribal communities, the Indian fisheries sector. That is from the perspective of fisherfolk. Well, friends, when you try to look at the literature that is existing with respect to the customary practices in Indian fisheries, there is a wealth of literature on this aspect. There are scholars like Martin Bavink, K.K. Baiju, Divya Karnad, etc., who have studied about the existence of customary practices in Indian fisheries. For example, Divya Karnad has studied about the customary practices existing among a community called Brahmeshwar community in the Sindhudurg district, which is on the southern side of the Maharashtra, that is on the coast, west coast. K.K. Baiju has studied about the customary practices which Honorable Justice Vishwanathan also pointed out, the Kadakodi system that exists among the fisherfolk community in North Kerala coast, particularly in the district of Kasargod. He has also studied about the customary rules and norms that have been evolved under the supervision of the Catholic Church in the coastal regions of the South Kerala coast. Martin Babank has in fact studied about the customary practices that exist among the fisherfolk in Ramnath or the Ramanathapuram district in Tamil Nadu. So there is a wealth of literature, and all these literature indicate two broad trends. And those two trends are, these customary practices is generally associated with small scale, artisanal and traditional fishing communities. And second trend that is visible is these customary practices are better enforced within small communities. And compliance with these customary rules is achieved through cultural rituals, that is through association with religious institutions, associated with caste, kinship ties, and even professional homogeneity. So we should keep these aspects in mind when you try to address this theme. So moving forward, is it really possible to integrate, and is it necessary to integrate customary practices into formal legal systems to achieve sustainable ecosystems? Definitely. And that is what precisely the international instruments would also say. For example, the FAO Code of Conduct on Responsible Fisheries, FAO CCR, which is a soft law benchmark for fisheries governance particularly. I'm not going into the details, I'll just specify one important clause in Article 7.2.2, says fisheries management systems should take into account relevant traditional practices, the interest of artisanal or subsistence fishers, and the need to avoid conflict. So this is what the CCR would say about the need to integrate customary practices into the formal legal systems. And the obligation, and India of course is a member of the FAO and is obliged to implement that. Then with regard to the SSF for the small scale fisheries, you have the FAO voluntary guidelines on securing sustainable small scale fisheries in the context of food security and poverty eradication. And this FAO SSF guidelines would in paragraph 5.15 urge the states, FAO members, to recognize community-based and customary governance system and integrate them into broader governance framework. We have this Montreal Global Biodiversity Framework, a very important international framework that has been developed recently to achieve certain objectives with regard to biodiversity conservation, and that also emphasizes on integrating or accommodating customary practices into formal legal systems. Though the SDG 14, which talks about life before water, does not specifically talk about customary practices, in fact, SDG 14 would indirectly require states to provide access for small-scale fishers and artisanal fishers to marine resources and markets. So how do we move forward with regard to this? So though there have been some attempts in India to recognize the rights of traditional fisherfolk, I would recall the attempt that was made by Mr. Jairam Ramesh in 2009, immediately after the enactment of the Forest Rights Act. A bill was drafted, in fact, a draft of that bill is available in the public domain. It's called Traditional Marine and Coastal Fisherfolk Recognition of Rights Bill of 2009. That bill, in fact, made an attempt to recognize the rights of traditional fisherfolk, and that was a follow-up of the MS Swaminathan Committee report titled Final Frontiers, in fact. But in India, we have not had an opportunity to truly integrate, or a formal system to integrate customary practices into formal legal systems. So my takeaway, or the takeaway from my talk would be that it is necessary and essential to integrate customary practices into formal legal systems, but whether is it necessary first to codify customary practices and then go for further, it's not an ideal option, because customary practices adapt to social, ecological, and cultural changes, and hence keeping them uniform would not serve the purpose. So ideal way would be to maintain some flexibility within the customary practices and integrate them appropriately so that the sustainable ecosystem objective can be achieved. And second thing would be, is it necessary to standardize cultural practices? That again is very difficult, because cultural practices differ from region to region, and it is very difficult to standardize it by ignoring the need for local specificity. So any attempt at integrating cultural practices into formal legal systems should provide some flexibility to the cultural practices or cultural norms. At the same time, they should be appropriately accommodated after due deliberations with the stakeholders, and that is what I would like to submit. Thank you very much for your patient listening.
Thank you very much for that interesting ideas and recommendations for application of customary practices. Now, let me first welcome Honorable Justice D.K. Singh, Judge, High Court of Karnataka, and at the same time inviting him to deliver his speech. Sir, you have 6 minutes for your speech. Thank you.
Good afternoon to one and all. Honorable Justice B.B. Bhakru, the Chief Justice of Karnataka High Court. My brother judges sitting in front of me, Justice Nambiar. The dignitaries on the dais and off the dais. 6 minutes, it is a, I think, I will try to wrap up my speech within the time frame allotted, keeping the discipline, particularly judicial discipline. And when my Chief Justice is on the dais, then I have to be more careful in observing the discipline. First of all, I must thank CLEA for organizing this 2 days conference on a very relevant topic regarding the fishermen folk rights. The community which is not, though it contributes and it provides a vital food chain, but its rights are not recognized, though the rights of the forest dwellers are recognized way back in 2006 by legislating act. So with this, the organizers of the CLEA, they deserve all applaud for choosing the topic to bringing the forefront the rights of the marginalized community, which receives raw deal when the development projects dislodge the community from their natural habitats and their customary rights of fishing and livelihood. I have got a written speech. I don't know how far I will reach in 6 minutes. 1 minute is already there, but I will wrap up. I start my speech with the faulty development model, which is not only in India, but I believe in other parts of the country also, is adopted without considering its long-time effect on the habitats, the human beings, and the environment. I will start with a development model in respect of a Singrauli, a place in Madhya Pradesh, which is bordering Uttar Pradesh. In 1970s, this region became synonymous with the large-scale coal mining and thermal power projects. On the surface, these ambitious ventures were heralded as engines of national development and progress. However, the reality has been far from delightful. By the late 1980s, estimates indicated that between 2 lakhs to 3 lakhs people had been displaced from Singrauli, and not just once but repeatedly. With each new project, entire communities found themselves uprooted, faced to abandon the land and had sustained their lives, and culture for generations. Rehabilitation and resettlements were promised at every turn. However, for most affected families, these promises translated into relocation to colonies and forest dwellers. Many were reduced to wages, laborers working on very land that had once belonged to them and they owned it, is stripped of independence and their dignity. Ladies and gentlemen, the tragic story of Singrauli is not just a cautionary tale about the consequence of unbalanced development. It is a reminder of the urgent need to center indigenous voices which making decisions that will dramatically alter their lives. There are Indian legal framework that surely embrace custom and sustainability. One of the cornerstone of this effort is the scheduled tribe and other traditional forest dwellers recognition of Forest Rights Act 2006, commonly known as Forest Right Act. This law was a response to a decade of marginalization of forest community. Another pillar is the Panchayat, extension of Scheduled Areas Act 1996, which extends the constitutional Panchayat local governance system to India's 5th schedule tribes areas, but with important custom-sensitive provisions. It mandates that the notified tribal regions, traditional Gram Sabhas must be at the center of governance. This law recognizes that tribals have their own customary ways of self-government and seek blend of modern democracy with traditional institutions. Now, any discussion of custom and law in India must speak of not just forest but also fish. Our indigenous tribal communities mostly inhabit forest and hills, whereas the traditional fisherfolk sustain themselves along coastal and rivers. Both share a profound ecological consciousness and the culture of subsistence living, yet there is a stark difference in how the law treats them. The gap has real consequences. Lacking formal titles or legal standing, fisherfolk are easily displaced by coastal development, pollution, or restrictive conservation zones that ignore their livelihood needs. We see this is a struggle of fishing hamlets against large port tourists. Large ports, tourist resort, or fishing bans that don't consult them. It is not time to remedy this imbalance. This is a question. Should the fisherfolk who sustain our food security and steward our coasts not enjoy the same dignity of legal protection as forest dwellers? Traditional fishing communities in Kerala coastal districts include 3 districts are facing significant challenges as a result of combination of natural and man-made factors. Coastal erosions has worsened in recent years, destroying homes and pushing families to flee. At the same time, development initiatives in such areas have caused additional relocation. These villages, which rely only on fishing for a living, are under threat from environment and infrastructural development. One of the most pressing challenges is the destruction of the houses. In multiple locations, sea waves have caused into residential neighborhoods, causing houses to collapse and property to lost. I'll take 1 minute, if you permit. The state government launched rehabilitation programs such as Punargraham. However, their implementation has been delayed or incomplete. Many families continue to live in temporary shelters or inadequate accommodation while they wait for permanent homes. Another significant barrier is the loss of livelihood. Relocated families frequently and themselves living far from coast, making it harder to continue fishing. This immediately impacts their income and food security. Women and children also have difficulty accessing schools, hospitals, and other services in their new places. Having talked about the difficulties being faced by the fisher folk in absence of the legal framework to protect their rights, what is the way forward and what is the conclusion? I conclude in the 2 sentences. The fisher folk community, unique due to their source of livelihood being water, bodies and coastal lines of open seas, find themselves outside the periphery of legal recognition when there exists no remedy in law to restitute or compensate their displacement, induced deprivation on account of economic development, encroachment, and environmental crimes. The struggle of Singrauli and Kerala are not distant tragedies, but they are living cause to conscience. It is time we shift our concerned attention to fisherfolk in the hope that the custom and sustainability gives us the roadmap, or rather the path, to be aid of the deprived. Thank you. Thank you so much.
Thank you very much, sir. Now, may I warmly welcome Honorable Justice Sam Koshi, Judge, High Court of Telangana, and at the same time, may I now invite you for your speech. You have very valuable 6 minutes, sir.
Honorable Chair, Justice Justice, Chief Justice Karnataka, Justice D.K. Singh, all the distinguished speakers on the dais, Brother Justice Nambiar, Justice Sinha from Nepal, all the august gathering, a very good afternoon. I'm sorry for getting late for the session. In fact, there were 2 simultaneous conferences going on, and incidentally, the time for the session in which I was clashing. Since the host has already said I've got just 6 minutes, I'll just request her to start my 6 minutes now. She says that 2 minutes have already gone. Anyway, and we are talking of a sustainable ecosystem and the customs and laws that are. An ecosystem is a network of living organisms interacting with their physical environment. It functions through their energy flow and nutrient cycling, creating a self-controlled biological system where all components are interdependent. Now we have reached a stage where laws have become essential for the sustainability of this ecosystem. The law supports the sustainable ecosystem by establishing legal frameworks in the use of natural resources, and also ensures that the human development does not compromise on the stability of the future generation. Through environmental rule of law, a legal system addresses threats to the ecosystem, establishing environmental rights and obligations, simultaneously encouraging accountability for environmental harm that are there, which has to be catered under the legal framework for a sustainable ecosystem. The environmental rule of law could be in the form of framing of policies for conservation, developing international agreements, and encouraging a shift from the otherwise pure market-based economic growth towards a more holistic approach that values ecological integrity with the social equity. There has to be a balance struck between human needs and the ecological integrity, which can be struck by promoting principles like the precautionary approach, take intensive steps to address the environmental degradation, promoting conservation of the environment, ensuring accountability for environmental harms, and foster a system where the development and nature can coexist. In the process of ensuring sustainable ecosystem, the laws, the rules, and the policies and the international agreements have to be in such a way
where the natural resources are managed in a way with an equally strong concern being shown to the conservation of these natural resources. If we permit continuous environmental degradation, the future generations will suffer enormously. Hence, it should be ensured that the progress meets present-day needs without compromising the future generation's need. It is in this regard that a balance has to be struck in the course of human development along with the need to preserve the natural ecosystem that we otherwise have. India presents a unique landscape for examining the integration of the traditional knowledge system with modern legal frameworks for environmental governance. With its rich biodiversity, diverse indigenous communities, and complex legal history, India offers valuable insights with both the challenges and opportunities of developing sustainable ecosystem management models. Some of the points that needs to be catered is the constitutional and the legislative framework, the forest rights and the traditional conservation, protection of the sacred groves and customary conservation, water governance and the traditional systems, geographical indications and traditional knowledge, traditional pastoralism and grassland management, marine customary rights and coastal management, which is more relevant when we talk with the keeping the state of Kerala in its context, climate adaptation and the traditional knowledge, challenges and barriers to the integration of the system. Despite promising development, significant challenges remain in integrating the customary and the formal legal systems in India. Centralized natural resources, governance continues to marginalize traditional institutions. Analysis of 172 environmental conflicts documented by the Environmental Justice Atlas in India reveals that 73% involves dispute between customary rights claims and the state development priorities. Institutional barriers include fragmented administrative responsibilities across the multiple agencies, limited recognition of the customary institutions, the inadequate mechanisms for meaningful participation in decision making. Of 14 major environmental laws reviewed, only 3 certain provisions for meaningful consultations with traditional knowledge holders. The pathway forward requires policy recommendations. Several promising pathways exist for better integration of customary and formal legal systems in India. Strengthening the implementation of existing legal frameworks, particularly the Forest Rights Act, the Biological Diversity Act, through improved institutional coordination and adequate resource allocation. Develop formal protocols for documenting and incorporating traditional ecological knowledge in environmental impact assessments and the natural resource management plans. Establish specialized environmental courts with representation from both formal legal experts and the traditional knowledge holders, building on the experience of the National Green Tribunal and its functioning, which has become so relevant these days. Create legal frameworks that recognize biocultural community protocols as legitimate instruments for governing access to the traditional knowledge and genetic resources. Reforms educational curricula for environmental professionals to include the traditional ecological knowledge systems and principles of legal pluralism. To conclude, I would just say India's constitutional commitment to both modernization and cultural preservation creates a unique opportunity to develop integrative legal models that draw on the best of both the traditional and the contemporary approaches. and empirical evidence strongly suggests that such integrated models can deliver superior outcomes for diversity conservation and also climate resilience and community well-beings. As India navigates complex environmental challenges from climate change to biodiversity loss, through a thoughtful integration of customary norms with formal legal frameworks offers a promising pathway towards truly sustainable eco-governance. This integration represents not a retreat to the past but rather a sophisticated synthesis that honors traditional wisdom while embracing modern scientific understanding and the institutional frameworks. Thank you. I thank the organizers for giving me this opportunity. Thank you.
Thank you very much, Your Lordship. Now we are moving on to the discussions, and we have 15 minutes and 5 speakers. First, let me invite Dr. Beulah Shekhar, Chair Professor of Criminology, Loknayak Jayaprakash Narayan, and National Institute of Criminology and Forensic Sciences.
A very good afternoon to the dignitaries on the dais, and I have to go at a breakneck speed to cover like the Vande Bharat in 2 minutes. Okay, so now the title itself shows how the organizers of this conference have already anticipated that there are some faults in the current laws and we need to look for other models. So customs law and sustainable ecosystems. So all these three blended together would be the ideal legislation and the legal format that we need to look at. So before we do that, we need to understand how the current laws, though very well-meaning, well-intentioned, have not addressed the global warming or the carbon footprints that we are facing today. So now we need to see how lack of enforcement, there are a lot of loopholes there as well, and then though we have those principles, these current laws are based on the principles of the polluter pays and the precautionary caution that they are supposed to take. But this does not suffice, so we need to move beyond this and see what are the hiccups there in the current laws. The enforcement gap, of course, we know because of the borders. We saw how a poacher had hoodwinked all the 3 states together and the central government before he was finally caught in our area. And then the one-size-fits-all approach, that is another loophole that has to be addressed. So we need to understand the difference between exploitation of resources and use of resources for the sustenance. So this is another area that we need to address when we're looking at a new format. And comes a focus on punishment, like our Honorable Advocate General of India was saying, that the adversarial system, there are a lot of loopholes there as well. So we focus on the punishment, we focus on the fines, we do not look at the whole picture, and we do not look at the restoring the community, restoring the environment for the victims. So that retributive justice vis-a-vis the restorative justice. This is something that we need to think about. The restorative justice will focus on the victims. And I'm glad that the organizers, in the midst of all the legal luminaries, have decided to have me on board as a victimologist. So the UN Declaration, the 1985 UN Declaration on Basic Principles of Justice for Victims of Crime and Abuse of Power gives a lot of rights for victims. So we need to, in the new legal format, include the victim justice as well. Justice Krishna Iyer has, Honorable Justice Krishna Iyer has clearly said that the victims are the Cinderella of the current criminal justice system in India. So we need to look at that. And finally, we need to, what we need to do is look at how we can make a new format, and that will be with legal pluralism. We need to recognize the coexistence of multiple legal systems within the community. So 2 systems within a particular jurisdiction, that we need to look at, and rights of nature as well. We tried to, it was done in Bolivia, the rights of Mother Earth, and the river that the previous speaker was talking about Wang Wei, also had the rights of a legal person. So we need to do something to that effect. In 2017, the Uttarakhand court passed an order, but it was overthrown by the Supreme Court again. So we need to talk about the rights of nature. And finally, the co-management. We need to see how we can work the legal systems with the community needs and with the community to get a new format for a legal system that would address the ecological needs of the community as well. And the sustainable developmental goals are a fine pointer. They have 10 goals out of the 17 that talk about only the sustainable development. So that gives us a good lead as well. So thanking the organizers for giving me the opportunity and congratulating them on this wonderful organization of this conference. Let me bid adieu. Thank you.
Thank you very much. Next, may I invite Mr. K.R.R. Ariyapamani, Advocate and Vice President, CLEA India.
Good evening, good afternoon, good morning. Because it's an atmosphere of 180 seconds, I have to cover everything. There is a well-known poet of Kerala, Tanjudha Ramanujan Eluthachan. He says in two literatures, one is in Ramayana Killipati and Mahabharatam Killipattu. In both literature work, he speaks about the values of nature and about the tribal and fishery people. There is a Thirukural, the world poet Thiruvalluvar says, Serke arandum kadendum ulangandu iyarkai arindu sega. Even if one has a knowledge of how to act through books and learning, it is essential also to understand the nature of the world and to act in accordance with it to be successful. So we have to go along with the nature. The tribal people are the only people and the fisher people are the only community who deal with the nature. So already this is the place of Kaudiyar, that is the palace of Travancore king. We are deciding the fate of the weakest section of the people and about the natural resources which have been enshrined in the Article 48A and 51AG of the Indian Constitution. It is in continuation of our Kovalam declaration. I request the chairperson, Honorable Justice K.V. Vishwanathan, and co-chair, Honorable Justice, Chief Justice of Karnataka High Court, to include some important subjects in the declaration of Kaudiyar declaration, strengthening the existing laws which protect the rights of the fishermen and the tribal people, and to establish courts as a practicing lawyer in the district courts. I feel that the Tribal People Act has to be enacted separately apart from SC/ST Prevention of Atrocities Act 1989. And I also suggest all the key speakers, particularly Lordships, have given an outlet of what are the acts which have been there, and Forest Rights Act 2006. We have to update all the acts in the Kaudiyar declaration. And I record the presence of as a Bar Council member of Tamil Nadu and Puducherry, I record the presence of my Kerala State Bar Council Chairman, Sri Ajit Kumarji. It's a great privilege, and I indebted to my mentor, Professor Shivakumar, for giving me an opportunity to share with all legal luminaries. I wish all the success to the organizers of the function, particularly Kerala State Legal Law Academy volunteers. Thank you.
Thank you very much. Next, I would like to invite Dr. P. George Giri, Advocate on Record, Supreme Court of India.
Respected dignitaries on the dais and off the dais, a very good afternoon. Custom, law and sustainable ecosystems, legal models for a convergent future is a thought-provoking topic that explores the intersection of traditional customs, legal frameworks, and environmental sustainability. As we face growing environmental challenges, it's essential to explore how our legal frameworks can support a convergent future. Indian customs and traditions have long emphasized living in harmony with nature. Many ancient texts, such as Vedas and Upanishads, contain principles and practices that promote environmental stewardship. For example, ahimsa towards all living things, Vasudhaiva Kudumbakam, recognizing the interconnectedness of humans and nature, Panchabhuta, acknowledging the importance of earth, water, air, fire, and space. However, modern laws often prioritize development over sustainability. To bridge this gap, we need legal models that incorporate traditional knowledge and scientific research. This convergence can help us create more effective conservation strategies and ensure equitable development. India has a robust legal framework for environment protection, including the Environment Protection Act 1986, the Forest Conservation Act 1980, the Wildlife Protection Act 1972, the Biological Diversity Act 2002, etc. However, there is scope for improvement in implementing and enforcing these laws. Sustainable ecosystems are crucial for maintaining biodiversity, supporting livelihoods, and ensuring ecological services. India's rich natural heritage, including its forests, rivers, and wildlife, requires effective conservation and management. A convergent future implies integrating traditional knowledge, modern science, and legal framework to achieve sustainable development. This approach can support community-led conservation initiatives, promote sustainable livelihoods, enhance environmental governance, foster climate resilience. Some potential legal models for a convergent future include Community Forest Rights Act, Environmental Impact Assessment, Traditional Knowledge Protection. Law is not static, it is evolving. So according to the needs of the society, we have to amend the existing acts, or if there is no acts, then we have to enact new acts to suit the needs of the society. That is the need of the hour. By exploring the intersection of Indian custom, law, and sustainable ecosystems, we can develop innovative legal models that support a convergent future, balancing human needs with environmental sustainability. By embracing this convergent approach, we can protect India's rich biodiversity, support local communities such as fishermen and tribals, and ensure a sustainable future. Let's work together to develop legal frameworks that prioritize both people and the planet. Thank you.
Thank you very much. Let me now invite Ms. Reshmi Ayesha, Director and CEO, KIMS Health, Vice President, Telemedicine Society of India.
Namaste, respected and most honored dignitaries. Honorable Attorney General of India, he was here until a minute ago. Honorable Chair and Co-Chair of the session, stalwarts of law, gatekeepers of justice, my teachers, and all my sisters and brothers. Across the Commonwealth, nations are bound not only by shared history, but also by shared challenges: climate change, resource depletion, and the struggle to balance growth with sustainability. Yet, it is the indigenous tribes and fisherfolk who best show us how to live in harmony with nature. In India, and especially in Kerala, this truth is vivid. The tribal communities in Wayanad and Attapadi have long practiced forest stewardship, taking only what they need and protecting the biodiversity. And along Kerala's coastline, fisherfolk live by the rhythm of the sea, knowing when to cast the nest and when to let the ocean heal. Their lives remind us that sustainability and subsistence are not opposites, but partners. In the rough 2.5 odd minutes that I get, let me ask you a question. Could you take a minute and think about your parents, your mother and your father, just their names, and your grandparents, some of the people are really old here, but I'm sure you would know your grandparents. What about your great-grandparents? Well, I think I would not be too wrong to say that each of us can trace our ancestry back to the so-called Adivasi or the fisherfolk. And being a Keralite, I assume one of my poor ancestors was also converted, either by marriage, which I assume to be a little happier person, or maybe by forced rape to become a Muslim. And here I am, possibly, slightly fairer in complexion, probably, living a different style of life. My families, my real families, live in the mountains and the seashore with more challenging lives. So whether it is the rising seas, the marine debris, the oil spill which disrupts the fishing and livelihood, or the deforestation and the climate change undermining the wildlife and the tribal subsistence, similar changes echo across the Commonwealth. But there is another urgent need too, the healthcare resilience. For in many remote villages and coastal villages, healthcare is still a challenge. Here, telemedicine can be a lifeline. By connecting a coastal clinic to urban specialists or enabling remote consultations during floods, early detection of tuberculosis and many other emergency care can be given. But for its promise to be real, we need stronger laws, better digital infrastructure, and reliable safeguards so that the telemedicine becomes trusted, safe, and accessible for all. Right now, we do have the telemedicine practice guidelines made in 2020 amidst the COVID, and we had to survive. But I think it is need to deliberate, and we need to include telemedicine as part of our legal framework. And Telemedicine Society of India looks forward to work hand in hand with the government as well as associations like CLEA to bring out the best for our nations. To support the tribes and fisherfolk is not charity, it is justice. Their survival strengthens our collective survival. Today, we have already deliberated on how principles of polluter pays, circular economy, etc. should become the cornerstones which are already being practiced in some of the other countries. Let us also keep in mind the enormous detrimental effect of religious intrusion, the use of drugs, etc. on indigenous communities, and therefore the legal framework to stringently address these issues. Let us be beware that these special privileges we need to safeguard our indigenous tribes are not to be used by other religious minorities to keep their minorities under check. Just a quick reminder about the role that CSR can also play in the overall benefit of our brethren, and therefore the legal guidelines for utilizing the multinational companies' profit for giving back to the community from which they make this profit. To conclude, adequate representation of the communities in making law, availability of basic facilities including health, legal framework to capture these needs by utilizing the special provisions of our constitution, to ensure that these frameworks are not misused by religious or other fringe elements. Nation above all, nationality above all. Let the diversity of the topographical challenges unite us, and those of cultures that come through religious interventions be forgotten under the Uniform Civil Code. As the Bhagavad Gita reminds us, as we believe and act, so the world becomes. I think it is said, Yado Bhava, Tado Bhavati. I'm not well versed in Sanskrit, but thank you. Vande Mataram.
Thank you very much. Next, I would like to invite Mr. Salman Qasmi, doctoral scholar, Indian Law Institute, and convener, CLEA Asia.
Certainly, Mother Earth has its own music for those who wish to listen. So, and after witnessing the God's own country, I am 100% sure that the indigenous people, the fisherfolk, and the tribal communities knows the taste of earth music better than all of us. Respected dignitaries on the dais, Honorable Mr. Chief Justice Pibu Sir, Honorable Justice D.K. Singh, Honorable Justice Sam Koshe Sir, and of the dais. So, as the chair for the session in the starting stress and highlighted what's the importance of the fisherfolk, that how the Kerala floods in 2018, they protected the water and protected the communities and we people like us. And Honorable Chief Justice, the co-chair, highlighted how the 42nd Amendment of the Constitution has tried to, integrate the basic principles of the protection of the environment. And taking inspiration from the Kumrikon Declaration last year, I am just try to summarize thing that the path to resilient economy and ecosystem is through synergy, the blending of custom and law. Custom shows us how to live sustainably, help laws scale and adapt these lessons for a rapidly changing world. Let us move from viewing custom as separate from law to understand it as it's a foundation, a resource for drafting, reviewing, and regenerating future just legal frameworks. The future of sustainability depends on viewing the wisdom of custom into the precision of law. By doing so, legal models will not only protect nature, they will empower communities, foster innovation, and ensure justice across generation. The law we design today, inspired by both tradition and science, will define the legacy we wave and we leave for tomorrow. Thank you so much. Thank you, everybody.
Yes, sir. As a token of our gratitude and deep respect, we would now like to felicitate our distinguished dignitaries. May I invite Professor Dr. S. Shivakumar, President CLEA, Professor K. Anil Kumar, Director Kerala Law Academy, and Bar Council of Kerala Chairman Ajit Kumar sir, to kindly felicitate our distinguished dignitaries. Honorable Mr. Justice Honorable Mr. Justice Vibhu Bhakru, Chief Justice, High Court of Karnataka. Honorable Mr. Justice Sam Koshe, Judge, High Court of Telangana. Honorable Mr. Justice D.K. Singh, Judge, High Court of Karnataka. Dr. Jacob Joseph, Professor of Law and Associate Dean, Savita School of Law, Chennai. Dr. Blula Shekhar, Chair, Professor of Criminology, Lok Nayak Jayaprakash Narayan, and National Institute of Criminology and Forensic Science. Mr. K.R.R. Ayyappa, Advocate and Vice President, CLEA, India. Dr. P. George Giri, Advocate on Record, Supreme Court of India. Dr. P. George Giri, Advocate on Record, Supreme Court of India. Ms. Rashmi Aisha, Director and CEO, KIMS Health, Vice President, Telemedicine Society of India, Kerala Chapter. Mr. Salman Kashmi, Doctoral Scholar, Indian Law Institute, and Convener, CLEA, Asia. Dr. Binu Moleke, Director, School of Legal Studies, QSAT. Dr. Dakshina Saraswati, Associate Professor, the Kerala Law Academy Law College and Chief Conference Coordinator. Thank you.
Respected dignitaries, distinguished jurists, scholars, and esteemed participants, as we conclude this profoundly enlightening session, it is my bounden duty and immense privilege to convey our collective gratitude. At the very outset, with the deepest respect, I acknowledge Honorable Mr. Justice K.V. Vishwanathan, Judge of the Supreme Court of India, the chair of this session. We have been listening to the most thought-provoking and informative words delivered by Lordship. On behalf of everyone present here, I extend a hearty thanks to your Lordship. My profound appreciation also flows to the co-chair of this session, Honorable Mr. Justice Vibhu Bakru, Chief Justice of High Court of Karnataka, for the Lordship's insightful reflections. I extend my heartfelt thanks to Dr. Binu Moleke, Director of School of Legal Studies, CUSAT, for her warm welcome address. I extend my profound thanks to our chair, Professor Dr. Kogla Ma'am, Professor at the Faculty of Law, University of Colombo, Sri Lanka, and Vice President of CLEA Asia for anchoring this session with scholarly precision. I also extend my special thanks to all the respected speakers and discussants in the dais. A special note of gratitude is due to the organizing committee, facilitators, rapporteurs, and the attentive audience without whom this session would not have achieved its intended brilliance. Thank you all.
Everyone, please note the lunch is served upstairs. Please proceed. Ready, Anas? എല്ലാവരും ഊണ് കഴിക്കാനായി മോളോട്ട് പോകാൻ അഭ്യർത്ഥിക്കുന്നു. എല്ലാവർക്കും മോളാ സർ.
recognize a world untouched by time, the vibrant culture of its tribal communities. These are the people who live in harmony with nature, whose traditions are as old as the land itself. For centuries, the tribes of Kerala have carried forward a way of life that celebrates simplicity, spirituality, and the rhythms of earth. Their homes, crafted from bamboo, leaves, and clay, stand as living symbols of sustainable living. Every tool, every ritual, every melody is drawn from the forest around them, blending human existence seamlessly with nature's bounty. Step into their world, and you will find festivals alive with color and rhythm. Dances performed around the fire, the steady beat of drums and chants that echo through the valleys, and each ritual tells us a story, not just of faith, but of a community's bond with the earth. The tribal attire, adorned with beads, feathers, and vibrant fabrics, reflects not only beauty but also deep cultural meaning. The tribes of Kerala are also skilled artisans. They craft bamboo baskets, wooden sculptures, and intricate ornaments that carry the essence of their identity. Each piece is not just an object, but a story of patience, creativity, and connection with the natural world. But what truly makes Kerala's tribal culture remarkable is the philosophy behind it. A respect for nature that goes beyond survival. They do not just live in the forest, they belong to it. Every festival, every prayer, and every tradition is a reminder that human life is sacred only when it honors the earth. For the traveler seeking more than just sights and sounds, Kerala's tribal
Good afternoon, everyone. Please take your seats and kindly ensure that your mobile phones are in silent mode. Our guests are here. I request the dignitaries to kindly take their seats on dais. Namaskar and a very good afternoon to each and every one of you. On behalf of the Commonwealth Legal Education Association and the organizing committee, it is my privilege to welcome our esteemed dignitaries, respected guests, distinguished participants, faculty members, students to the valedictory ceremony of the International Conference on Convergence of Sustainability and Subsistence, espousing the cause of indigenous tribals and fisherfolk. As we draw to the close of this remarkable gathering, we reflect with gratitude on the insightful deliberations and shared resolutions that have marked. This conference was more than an academic forum. It was a coming together of hearts and minds dedicated to justice, sustainability, and the well-being of our indigenous tribals and fisherfolk community. May I now invite Advocate Nagarajan Narayanan, Director, the Kerala Law Academy Law College, and Co-Chairperson, Organizing Committee, to extend the formal welcome and share his reflections at the closing ceremony.
Respected Honorable Mr. Justice Vikram Nath, Honorable Judge of the Supreme Court of India, other Honorable Judges on and off the dais, dignitaries on and off the dais, and dear friends and dear ladies and gentlemen. Now, the 2 days deliberation were really effective is what I have seen from the field. The deliberations were direct. Yesterday, I had the fortune to witness the indigenous people of our home, the tribal people, the tribes from our state, and also the fishermen having direct interaction with the Judge of the Supreme Court, communicating with His Lordship, and that would show the spirit of today's conference. And just 2 words I may add is the fundamental thing, the elementary basic thing is that the indigenous tribes or indigenous people, the knowledge they have, the traditional knowledge they have, no wise man and no knowledge can suppress that. No knowledge is above the traditional knowledge. For example, the Manan tribe from our forest, it is said that they know how to speak to the elephant. Nobody else has got that communication. There are tribes. From stories I hear from the ground field staff from the forest, I hear stories where how the tribals communicate, how they peacefully coexist. There is no human-wildlife conflict in many tribal areas. They are very satisfied. And even in those areas where there are conflict, the tribes say, no, we don't have any issue at all. We don't want the elephant to be removed. Let them stay along with me. Let us have peaceful coexistence. So that is the knowledge they have. Just one more instance I can say is in Mangladevi. It's a remote place inside the Periyar Tiger Reserve. In Bangladesh, we have so many endemic plants. One plant, which I am told is that any person having diabetes takes that plant, his sugar level will come down and it will not go below his particular level. It will remain at the correct level. So that is an endemic plant, rare, endangered, and I don't know whether it is available there or not. But that is a knowledge which only the tribes have. So no medicine can go above the knowledge which tribes have. So let us celebrate the knowledge of tribes. This may be the first level. Let the Commonwealth Legal Education Association take it further at the global level, including in New Zealand, as you know, the Maori tribes. They have fought so many battles, and the Supreme Court of New Zealand has recognized, saying that the rivers have life, they are persons, and for the rivers, the tribes have come forward to protect them, representing them. So we have so many instances in our global level. Now to my duty, we have Honorable Mr. Justice Vikramnath sir as the chief guest of today's function. Now, the other day only I was hearing His Lordship saying that His Lordship has become so famous in the civil society, is being a talk all around the globe because of the judgment in the stray dog case. Maybe besides that, His Lordship was the first High Court Chief Justice to use YouTube live streaming in the entire India during COVID pandemic period. His Lordship is a trendsetter in many aspects. Now, we are very fortunate that we have such a eminent dignitary, such a learned dignitary, such a breaker with us. On behalf of all those present here and the Commonwealth Legal Education and the other host, I extend to you, sir, extend to your Lordship a very warm welcome. Then we have the Attorney General, our Venkataramani sir, so lovable. So whenever he sees me, he would hold my hand. And it's not just the top law officer of the country, but more than that, his attachment, his behavior to all, whoever it is, it doesn't matter who, big or great, a great personality, a great human, sir. Welcome to this function, sir. Then I have my own judges here, two of them, Justice Jayashankar Nambiar, sir. Now, we are always there in the court, nothing more to say. A great lover of humans. The other day only, one of the judges was saying in the other conference, His Lordship is so concerned about animals, sometimes he forgets the humans. But I'd say he's another great human. Well, I have been both at the better and receiving ends on his bench. Sir, we're very happy that you are here, sir. And you have always been here the whole day. That is something great, sir, to contribute to such a great topic. Welcome, sir, please. Honorable Mr. Justice Dias, I know his Lordship, I know him even before his Lordship became, all of them. I know them as lawyers also. Very erudite lawyer, representing great institutions like the railways and big companies. Besides that, he was so busy with other function. He was the kingpin, or he was the anchor. He was holding the anchor for the other function for the NALSA program. And after that, he's here. His Lordship also has so many judgments where reflects on the issues relating to human-wildlife conflict and similar issues. And also, I hope there will be more to come from His Lordship on tribes and indigenous knowledge and protection. So we are very happy to have you here, sir. On behalf of all present here and the Commonwealth Legal Education, I extend to you, sir, a very warm welcome. Thank you. Then the entire, the master of ceremony, the entire main person of the this conference is Dr. S. Shivakumar, a very important person in the entire country, in the sense he was a former member of the Law Commission, full-time member of the Law Commission, who has contributed a lot during that period as a member of the Law Commission. And his vision and everything that goes with this conference, it is everything related to him. He is the main person here, but still for the sake of formality, on behalf of all those present here, I welcome you, sir, to this function. Welcome, sir. Dr. Girish Shankar is another of my former colleague. He is also has done a lot of things in so many places for legal education. No time permits me to say all these things. On behalf of, he is also part of the organizer. For the sake of formality, I extend to you, sir, a very warm welcome. Ruji Sharma is there, and she is another organizer who is full-time here, so committed, running all around. Welcome, madam, to this function. Dr. Nebula is also here in the dais. On behalf of all those present here, I extend to Dr. Nebula a warm welcome to this function. And finally, I extend a very warm welcome to all the delegates, all the persons here, the judges, everybody here. Thank you all for coming here. Welcome all, please. Welcome. Thank you.
Thank you so much, sir. As a mark of honor and to welcome our chief guest, may I now request Professor Anil Kumar to present the Unavillu to our chief guest, Honorable Mr. Justice Vikram Nath. It is a traditional hand-painted ceremonial bow from Kerala that usually depicts scenes associated with Lord Vishnu. Traditionally, they are crafted and offered at Sri Padmanabha Swami Temple during Onam.
Into the grand festival of Onam. At first glance, it looks like a simple wooden bow, but in truth, it is a sacred masterpiece. Painted with glowing images of Hindu gods and goddesses, and each bow tells timeless stories of Lord Vishnu, Lord Krishna, and Goddess Lakshmi through vibrant hand-painted artwork that shines with life and devotion.
Thank you so much, sir. Moving forward to provide a brief report highlighting the outcomes of our conference, may I now call upon Dr. Girish Shankar, SS.
Good afternoon, one and all of you. Esteemed Honorable Mr. Justice Vikram Nath, Judge Supreme Court of India, all other esteemed judges on the dais, Honorable Attorney General, and my colleagues from CLEA and Kerala Law Academy. Respected judges of the dais and all other academia and other friends. Let me just briefly take you through a brief history or a brief account of what has happened in these 2 days. The International Conference on Convergence of Sustainability and Subsistence, espousing the cause of indigenous tribals and fisherfolk, was a collaborative venture of Commonwealth Legal Education Association with Kerala Law Academy Law College, in association with the School of Legal Studies, CUSAT, St. Dominic's College of Law, Kanjirappalli, and Kelsar and Kochi Metro Rail Limited. This conference builds upon the Kumaragam Declaration of 2024, which emphasized sustainability in transport, tourism, and legal innovation. The 2025 conference extended these commitments by embedding subsistence and sustainability as community-centered perspectives, ensuring that the concerns of indigenous and fisherfolk communities remain central in legal and developmental discourse. The International Conference on Convergence of Subsistence and Sustainability, espousing the cause of indigenous tribes, the present conference was inaugurated as a continuum of the Kumaragam Declaration 2024, reaffirming CLEA's commitment to community-embedded legal models. Justice Suryakant sir, who is the chief patron of CLEA, who inaugurated this international conference, underscored the role of law in making sustainability inclusive and accessible. Professor S. Shivakumar, who delivered the introductory address, highlighted the priority of integrating indigenous and fisherfolk concerns into legal education. Honorable Justice Nitin Madhukar Jamdar, Chief Justice of the High Court of Kerala, while delivering his special address, emphasized balancing development with ecological justice, while Dr. R. Venkatramani, the Chief Patron of CLEA, while delivering his special address, called for safeguarding subsistence rights through community-driven frameworks. Honorable Justice A. Mohammad Mushtaq pointed to the role of legal aid and service authorities in empowering vulnerable groups. Collectively, the inaugural framed the conference around law-driven sustainability, equity, and grassroots empowerment, navigating the sessions forward. The cross-section of the participation included judiciary, technocrats, and academia, which enriched the dialogue, making it both practical and futuristic. The rendezvous session, which was a fact-finding and open dialogue, that was one of the niche areas, one niche program that was undertaken by this conference. A rendezvous session that was organized on the day one created a platform for direct dialogue between indigenous tribals, fisherfolk, and the judiciary. The open forum enabled marginalized voices to articulate anxieties, livelihood struggles, and ecological concern. The Chief Patron of CLEA, Honorable Mr. Justice Suryakant Sir, as well as the President of CLEA, Professor S. Shivakumar, participated in that dialogue. Mainly, the dialogue revolved around having the complexion of a fact-finding in nature, gathering first-hand perspectives from affected communities, and has formally decided that as a post-conference measure, there will be certain fact-finding missions to go in detail about the ground, to work up the ground level details, particularly which revolve around these communities. The exchange revealed how legal education institutions and service authorities can be mobilized for grassroots empowerment. It was underlined that community-embedded dialogue is not an isolated exercise, but a continuum of consultation and accountability. So this portion of the conference was particularly significant as it shifted from formal presentations to active listening and participatory engagement, setting a model for future community dialogues. The first session, that's a plenary session, was on sustainable transport, port, island, and sea coastal challenges and legal innovations, chaired by the Honorable Mrs. Justice B.B. Nagarjuna, Judge, Supreme Court of India, and co-chaired by Honorable Mr. Justice M.M. Srivastava, the Chief Justice of High Court of Madras. The main propositions emerged was, one, sustainability in transport should be rooted in the rule of law with attention to both ships and transported materials. Second, maritime legislation, infrastructure challenges, and the development of small ports require urgent reform. Collaborative logistics and supply chain mechanisms were emphasized. Water Metro was highlighted as a regulatory and operational model addressing the polycentric governance issues. Academia and technocrats underlined the need for innovative legal frameworks for port, sea, and inland transport. Session 2, that was a technical session. Theme was Indigenous Tribals and Fisherfolk Identity, Law, and Recognition, chaired by Dr. R. Venkatramani, esteemed Attorney General of India, and co-chaired by Honorable Mr. Justice Apresh K. Singh, Chief Justice of High Court of Telangana. The propositions emerged were traditional and sustainable livelihoods of indigenous communities at times threatened by developmental projects and policy gaps. Concerns of fisherfolk highlight struggles of recognition, resource access, and ecological imbalance. And speakers stress community-led frameworks, recognition of tribal kinship, and safeguarding customary practices. And finally, comparative perspectives from South Asia underlined the importance of legal pluralism in protecting identities. Session 3, which was the last technical session, the theme was Custom, Law, and Sustainable Ecosystems, Legal Models for the Future. Chaired by Honorable Mr. Justice K.V. Vishwanathan, Judge, Supreme Court of India, and co-chaired by Honorable Mr. Justice Vibhu Bakru, Chief Justice of Karnataka, the propositions emerged were that customary practices, when aligned with law, can generate sustainable models of ecosystem development, ecosystem management. Judicial perspectives emphasize the role of law in balancing development with ecological preservation. Academics and civil society urged multi-stakeholder dialogue to develop adaptive legal frameworks. And suggestions included integrating criminology health perspectives and indigenous knowledge systems into into ecosystem governance. And now we are into the valedictory function. The sessions collectively underscored that sustainability cannot be reduced to policy rhetoric. It must be anchored in law, informed by communities, and open to global perspectives. This integrative approach reflects only the spirit of the present conference, but also a forward-looking vision where legal innovation continuously adapts to the needs of the vulnerable groups while strengthening global solidarity. This brief, I am submitting it to this august gathering. Thank you.
Thank you so much, sir, for briefly and beautifully capturing the findings of all the session. I now invite Senior Professor Dr. S. Sivakumar, President CLEA, and Senior Professor ILI to present his thoughts on the conference outcomes and way forward.
Esteemed Chief Guest, Honorable Mr. Justice Vikram Nas, one of the senior most Judge, Supreme Court of India, Honorable Learned Attorney General for India, Dr. R. Venkataramani, Honorable Justice Jaishankar Nambiar, Honorable Justice Dias, Honorable Chief Justice, Justice Bibu Bakru, Chief Justice of Karnataka High Court, Honorable Justice D.K. Singh, my esteemed members of Organizing Committee, Advocate Nagaraj Narayan, Dr. Girish Shankar, Professor Anil Kumar, Ruji Sharma, Nebila, the delegates from abroad, Sri Lanka, UK, Bangladesh, and other parts of the country, distinguished speakers, academics, guests, legal practitioners, policy makers, technologists, faculty members, and dear students, a good afternoon to all. This function, Lordship agreed for a chief guest. It is a continuation of CLEA activity from Honorable Justice Suryakant's, our chief patron, to Lordship is taking over. That is a welcome trend in our judiciary. All the senior most judges are with CLEA activities and legal education. Thank you so much, sir. As we have gathered here in the coastal capital of Kerala, cuddled between the backwaters and Arabian Sea, we are reminded of a deep interdependence between people, land, and water. Our conference has not merely been an academic exercise. This conference has reminded us that sustainability and subsistence are no longer be afterthoughts, but we have become our moral and strategic compass. This way forward must begin by transforming our institutions as law when rooted in justice and compassion. Law becomes a tool not just to regulate but to liberate, to give voice, visibility, and value to every citizen, especially those living at the margins of rivers, deltas, and coastline. The imperative that our legal education system evolved to meet this moment. We have to update what we teach and how we teach it. On content, let us focus on evolving courses such as maritime law, climate justice, indigenous and coastal rights, blue economy, environmental, social and governance of law, and sustainable finance, participatory environmental governance, law, technology, and climate resilient infrastructure. On method, knowledge alone is not enough. We must engage students deeply and directly with lived realities. Legal education must be experiential, justice-oriented, and socially rooted by encourage policy research, simulation exercise, and collaborative lawmaking labs that connect them with the real-world challenges. This work must be guided by what I call 3 I's. It must be intersectional in its approach, interdisciplinary in its methods, and intergenerational in its vision. It must span classrooms and courtrooms, rivers and research labs. Let us remember that Professor Menon gave us more than an institution. He gave us a philosophy, one that placed justice before prestige, community before conformity, and conscience before convenience. He believed that the law must travel beyond books and reach the lives it claims to protect. With this united vision, it is now my privilege and honor to present you the Kerala Declaration 2025, a solemn articulation of our values and our commitment to path ahead. With Lordship's permission and all of you present here, with your permission, I read this declaration. This declaration embodies our collective vision and commitment to a just, equitable, and sustainable future for indigenous tribals, fisher folks, and all communities dependent on land, forest, coastal, and inland waters in harmony with the environment. We, the participants of Commonwealth Legal Education Association International Conference 2025 on Convergence of Sustainability and Subsistence, Exposing the Costs of Indigenous Tribals and Fisher Folk, held in Thiruvananthapuram, Kerala. Recognizing the intrinsic link between ecological sustainability and human subsistence, affirming our collective responsibility to safeguard the rights and livelihoods of indigenous tribals, fisher folk, and all communities dependent forests, rivers, coast, and inland waters, and recalling constitutional guarantees, institutional commitments, and customary practices that enjoin us to act with justice, equity, and foresight. We hereby adopt this declaration and agree upon the following points. First, sustainability and subsistence as guiding principles. We affirm that sustainability, including environmental, social, cultural, and economic, must form the foundation of all development strategies in maritime, coastal, and inland water transport. We recognize the inseparable link between the health of ecosystem and the survival of tribal and fishing communities. Development must enhance the ecological resilience while protecting livelihoods. Second, legal protection for indigenous and coastal communities. We emphasize the urgent need to strengthen legal frameworks to safeguard the constitutional, customary, and human rights of tribals and fisher folk. For tribes, this includes protection of forest rights, land tenure, customary governance system, and cultural heritage. For fisher folk, this includes protection of coastal access, marine resources, and livelihood rights. Free, prior, and informed consent, FPIC, must be a negotiable prerequisite for any project impacting these communities. Third, comprehensive regulatory framework for maritime and water metro transport. We call for an early implementation and regulation of water metro project and allied margin transport initiatives. It is the imperative to establish a harmonized and comprehensive regulatory framework. This must integrate an environmental safeguards, livelihood protection, and climate resilience measures. Fourth, community-centric governance. We argue the institutionalization of participatory governance mechanism that ensure fisher folk and tribal representatives have a separate and equal representation for tribals and fisher folk in decision-making of forest governance, port planning, waterways development, and resource management. Fifth, climate resilient infrastructure and technology. We commit to promoting the climate-proof infrastructure, low-emission vessels, renewable energy adoption in ports, and sustainable forest management technologies that minimize tribal displacement and ecological degradation in line with India's Panchamriti climate pledge and IMO decarbonization targets. 7, ethical, inclusive, and cultural sensitive development. All development initiatives must respect tribal cultural heritage, sacred groves, and traditional ecological knowledge, as well as the ties of fisher folk to coast and waters. Equitable benefit sharing must be guaranteed for both communities. 7, strengthening legal education and capacity building. We call for an integration of sustainability, water law, indigenous rights, and climate governance into legal curricula at all levels. Law schools establish tribal environmental justice clinics to promote experience learning, including legal clinics, simulation labs, field work, and interdisciplinary research in coastal and environmental law. Financing the blue economy responsibility. We support the operationalization and strengthening of dedicated maritime, coastal, and tribal development funds. Along with this initiative, community-oriented financing mechanism to ensure the resources are channeled only into projects with demonstrable economic, environmental sustainability, social equity, and livelihood benefits both tribal and fisherfolk communities. 9, international and regional collaboration. We commit to fostering cooperation among Indian Ocean, territorial states, Commonwealth nations, and international bodies to harmonize standards, share the best practices, and jointly address threats to tribal rights, maritime sustainability, and community welfare. To this end, we further resolve to convene regular organization of conferences, dialogues, and collaborative platforms that bring together government, judiciary, academia, industry, and community representatives, thereby institutionalizing a culture of sustained engagement and shared responsibility. 10, commitment to future action. We recognize youth as an agent of change. Law students must be engaged through moot courts, legal aid projects, internship, and innovation challenges focused on tribal land, forest right, and fisher folk livelihood. 11, and last one, recognition of tribal autonomy and customary law. We affirm the right of tribal communities to preserve the develop their traditional governance system, language, cultural heritage, and economical practices in line with constitutional protection and the UN Declaration on Rights of Indigenous Peoples. We also pledge to advance these principles for our respective domains, ensuring that the convergence of sustainability and subsistence become a living reality for the present and future generations. Lordship, with your permission, we can adopt this declaration. Yes, then you can. We adopted this 31st day of August 2025 in Thiruvananthapuram, Kerala. We stand united to resolve to protect the rights of indigenous tribals and fisherfolk, uphold environmental stewardship, and pursue equitable climate resilient development. Regards, signature.
Thank you so much, sir, for your vision and providing a roadmap for collective action. It is now my honor to invite Honorable Mr. Justice C.S. Dias, Judge, High Court of Kerala, and Co-Chairperson, Conference Advisory Committee, to share his insights.
Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India, Honorable Chief Justice Vibhu Bakru, Chief Justice of the High Court of Karnataka, my esteemed brother judges, Dr. Justice Jaishankaran Nambiar and Mr. Justice D.K. Singh, Learned Attorney General, all the other dignitaries on and off the dais, students, and friends of CLEA. It is with profound privilege that I address you this evening in the valedictory session of this international conference of the Commonwealth Legal Education Association. Following the historic Kumaragam Declaration, we are once again gathered in God's own country to deliberate on matters that touch the core of human existence. While our deliberation was on sustainable transport, this conference has turned its gaze to an equally pressing concern, the sustainability and subsistence of indigenous tribals and fisherfolk. Thiruvananthapuram could not be a better, more fitting venue for these deliberations. The district is blessed with the coexistence of both tribal communities and the fishing families, embodying the very challenges that animate our discussion. Over the past 2 days, the eminent speakers have, I'm sure, engaged in searching debates and illuminating discourses, offering a panoramic view of laws, policies, and the constitutional principles that must inform our response to the challenge faced by these vulnerable communities. To speak of ecology without acknowledging human survival is incomplete, yet to talk of livelihoods without regard for ecology is a betrayal of sustainability. Both are interwoven strands of a single fabric. I'm sure, since Dr. Girishankar already explained to you all the 3 strands of this conference, I do not want to repeat it again. But I wholeheartedly congratulate CLEA on this wonderful Kerala declaration that has been just made by Professor Dr. Shivakumar, the leading light of CLEA. I am sure this conference, echoing the spirit of the Kumaraman Declaration, reaffirms the need to integrate sustainability and subsistence into the core of the legal education, judicial reasoning, and policy frameworks. Let us therefore resolve that we can speak of progress, and we do so with an unwavering commitment to equity, ecology, and justice. On behalf of this August Assembly, I extend my gratitude to CLEA and every participant who has enriched this conference with their deliberation. May the insights that we have gained from this conference find reflection not only in the academic discourse, but also in our judgments, advocacy, and policy making. Let us not forget, law is not an end in itself, but an instrument to secure justice for our environment, for our people, and for the generations yet born. Thank you, Jayant.
Thank you, Your Lordship. May I now invite Honorable Dr. Justice A.K. Jayashankar Nambiar, Judge, High Court of Kerala and Chairperson, Conference Advisory Committee, to kindly address the gathering.
Justice Vikramnath, Attorney General Mr. Venkataramani, my brother judges, Justice Dias, Justice D.K. Singh, Chief Justice Vibhu Bakru, other dignitaries on the dais, distinguished speakers, academicians, students, ladies and gentlemen. The valedictory function is normally a time for reflection, introspection, and probably deliberating on what you're going to do in the coming year. I was sitting in on today's discussions that happened in the morning, and I was not surprised to find that irrespective of the walk of social life that you were discussing, there seemed to be an air of exasperation with the non-inclusion of traditional knowledge, customs, indigenous knowledge with the modern law as we know it. And as I heard all of you give your talks this morning, and I know there was somebody who was behind you holding those cards, and most of you did not get to say entirely what you wanted to say because there was this gentleman who was coming, and the lady also, who was coming with this 3-minute, 6-minute rule. Yes, she's here. But I did that. If you were trying to get across the message that there is an exasperation, there is a shortcoming in our laws with regard to accommodation of customary laws and traditional indigenous knowledge, let me just bring to your notice that in 1950, January 26th, we adopted this wonderful document in our country, the Constitution of India. And I would request you all to pay serious attention to this document because it is the most spectacular legislation that we've ever had in this country. It took a great deal of deliberations and discussions to actually frame this document, 2.5 years plus. And when we ultimately gave to ourselves this constitution, if you look at part 3, which you're talking about, which is fundamental rights, Article 12 states very clearly what a law is, or Article 13 says very clearly what a law is. And a law, for your recap, includes customs.
Why is it that after 75 years, we are all huddled in this room lamenting on the lack of clarity with regard to whether traditional knowledge, traditional customs, indigenous people's customs are not integrated with our law yet? I think we need to, collectively, we talk about constitutional morality, we talk about commitment to our constitutional principles. We need to look at what it says. It's all there. And as far as implementation of those laws, implementation of those customs are concerned, please take it from me, there is nothing in the Constitution which says that the Constitution is the sole preserve of lawyers and judges. The Constitution, as a greatest constitutional biographer, Granville Austin said, is first and foremost a social document. It is not a legal document. Dr. Ambedkar, the architect of the Constitution, he himself in the Constituent Assembly said, this is not to be a lawyer's document. Everybody, probably it was Jawaharlal Nehru who thought that there should be more of a lawyer's phraseology used, but the majority in the Constituent Assembly were not in favor of that. Our Constitution is a social document, and that is how it will always be. If that is the case, then where is it a requirement for a judicial interpretation of it before you can act on it? So the first thought I want to leave with all of you as you further deliberate is this. The Constitution already has provisions which will help you attain your goals of integrating traditional knowledge with with the law modern law as we call it. Second is the theme that we are discussing here. We are talking about convergence of sustainability and subsistence. In a allied platform, we were discussing coexistence of humans and wildlife. Both these conferences are going side by side. Essentially, what are you talking about sustainability and subsistence? You're talking about coexistence. You're talking about give and take. You're accommodating the interests of another. More importantly, you need to understand and know the other in any transaction or in any relationship. And if that is the case, how do you get to know the other? You need to interact. You need to understand the other and find out what it is that prevents them from coming into the mainstream. You're talking about marginalized communities. You talk about indigenous people. You're talking about their customs, their peculiar habits, the traditional knowledge that they have. Why is it that despite all these years of independence and our becoming a republic, why don't we integrate this into our everyday lives? Your education system today does not contain a chapter on tribal culture. The indigenous people have to come and attend schools and colleges where the medium of instruction is English. If it's English, you're recognized in society. If it's your vernacular language, probably not. If you don't speak the English language, you're somehow seen as inferior. Why? And what are we doing about it after 75 years of working a democratic constitution? If we can't integrate our traditional knowledge into our daily learning, into our books, into what our children learn, why should a child belonging to a tribe be ashamed? And even if he or she is going to a school or a college, why isn't that boy or a girl being taught something that will be useful for his or her entire life? These are aspects which you need to keep in mind, and I would request you to please engage in further deliberations as to how to make this possible. Stop blaming the laws, stop blaming the lacunas in our laws. And third, most importantly, the obsession with rights in this country is something that I've never been able to get a grip of. You're all talking about rights, whether it's fishermen's rights, indigenous people's rights. What on earth is this obsession of rights? I do agree that when we gave to ourselves a constitution in 1950, we introduced a chapter, part 3, the most the most well-known chapter in our part in our constitution, fundamental rights. Please remember, the ancient Indian legal system was founded on the concept of dharma. Dharma loosely translates as duty. Why is it that when we, the people of India, gave to ourselves this constitution in 1950, we conveniently forgot a chapter on fundamental duties? That came 24 years later. So, when you're talking about rights, you can't have a conversation on rights without understanding the concept of duties. That's what makes for a balanced society. If you have rights, if you have a conversation on rights coupled with a conversation on duties, you will learn the art of limiting your rights. The Constitution will have self-imposed limitations on your rights. The content of your rights will be limited by the duties that you owe. And this is more important when you're talking about marginalized interests in society, whether you're talking about animals or other species, or even indigenous people, marginalized sections in our own society. Unless you understand that you have only so much rights as are qualified by the duties that you owe to the other in society. So please take care to understand what you have towards rights. Please remember that if you keep asking this question of what do I get from society, which is what you're essentially asking when you're trying to determine what is the content or scope of your rights. If you keep asking yourself as a society, what do I get from society for sufficiently long, all that it will make you is a very selfish society. With those thoughts, let me wind up. I know Justice Vikramnath has to take a flight to Delhi. I must, before I conclude, thank CLEA for organizing this 2 days of discourse and discussions, much needed in our society. The Law Academy, Nagaraj and team, and Professor Shivakumar, who's been spearheading this entire effort. He's been running around everybody to come to Trivandrum and God knows where else. But I think this is a spectacular effort that is taken by the organizers. I congratulate them and wish them well. Thank you.
Thank you, Lordship, for your insightful remarks. It is my distinct privilege to call upon Dr. R. Venkatramani, Learned Attorney General for India and Patron CLEA, for special address.
I would like to say something on the lighter vein, because when to have the word attention, right, is something very special. And, we're becoming a less attentive species. There's so many distractions in our mind, transactions, relationships. So, while you're assembled to talk about a certain section of the people, we want to talk about our lack of attention to those people. Our lack of attention has come because of a number of reasons. Just Nambiar talked about the Constitution. Constitution is like a big cake and a pie, and there is a lot of competition in using the Constitution. Like every morning I feed birds in my garden. There's a small bird, the crow comes, then the eagle comes, and then the peacock comes. One chases out the other, and there's a competition amongst them. And I keep wondering how much can I feed each one of them to their utmost fulfillment. So social justice we talk about it, Constitution we talk about it, means a space and an area and a framework and a mind particularly, fundamentally, to give room for every section of our community who need it most. Therefore, I congratulate CLEA for taking up this particular subject where I said sections of people who have not received the attention they ought to receive from all and each and every one of us. In the light of vein, Professor Shivakumar is very ambitious. He calls it a Kerala declaration because it comes from Kerala, right? And I would like to probably call it a national declaration of CLEA in order that the nation wakes up. I have nothing about Kerala, nothing, just in the light of it because so close to each other. It's a national declaration where each and every one of us will be able to arise because of the international conference. And people who come from Colombo, Bangladesh, and other parts of the world. But only way I can say the Kerala declaration becomes important because Kerala has wanted to occupy that space of the attention which we lacking. Therefore, I congratulate Mr. Shivakumar with a wonderful idea, and I'm sure with CLEA wanting to occupy the global scene in making more and more inroads into connecting legal education, meaningful, community-oriented legal education, and those community concerns which do not become part of the mainstream legal education understanding. So CLEA will make more and more journeys into it, and I'm sure that the subjects we choose will be those subjects where we talk about people who have not received attention from each and every one of us. And I do not want to say anything beyond that except to say that as a student of law, with 45 years of journey into this law, I find that the competition, which is a wide range and multitude of competition among human beings, and we call it equality, and we call it other social justice. So this competition is something which is exacerbated by today by market capitalism, and then we talk about regulation. I'm not talking from a doctrinal socialist point of view, because many ideologies have failed. We need to look at a greater ideology where the combination of the genius of all human people across the world can come together and say that there'll be no competition where none will be, go hungry, none will go to bed suffering from want, and none will go to bed by being, excluded from social, bondage and things like that. That's the kind of thing I think legal education must look at. And I'm sure with the presence of honorable judges of the Supreme Court and High Courts and legal community and a wide range of people assembled here, I'm so glad. And I think sure the reverberations of this conference will go beyond Kerala. And of course, certainly Kerala will occupy its place of pride. Thank you so much.
Thank you so much, sir, for your gracious thoughts. It is now my utmost respect to invite our chief guest for the evening, Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India, to deliver his valedictory address.
A very warm good afternoon to everyone present in this auditorium. Firstly, let me convey my deep sense of gratitude to CLEA, Dr. Venkataramani, Dr. Shivakumar, who literally compelled me to be here, and I feel privileged that I am here today. Thank you. It is my pleasure to deliver the valedictory address at this international conference on convergence of sustainability and subsistence, espousing the cause of indigenous, tribals, and fisherfolk. Over the past 2 days, meaningful deliberations have taken place that have drawn participants from across the Commonwealth. We have heard perspectives from the judiciary, from policy experts, from academics, from practitioners, and many like-minded people. What has emerged is not only the intellectual richness of this theme, but also its urgency. For what we are really speaking about is the survival of communities and the survival of the planet, and the law must act as the bridge that holds these two together. Sustainability and subsistence are sometimes spoken of as two different objectives. Sustainability is described in terms of carbon emissions, biodiversity, or long-term ecological balance. Subsistence is described in terms of livelihoods, food security, and daily survival. But for the indigenous tribes of our forests and the fisher folk of our coasts, these have never been opposites. Their very survival has always rested on living in balance with nature. They have practiced sustainability not as a slogan, but as a way of life. For them, subsistence is possible only when rivers are clean, when fish stocks renew, when forests regenerate. That is the lived reality of convergence. The challenge before us is to make sure our laws, our policies, and our systems of governance reflect this truth. Sustainability must never come at the cost of subsistence, and subsistence must never be framed as the enemy of sustainability. The dignity of survival itself must be recognized as a measure of sustainable development. Consider transport and port development. Ports, inland waterways, and shipping networks are seen as engines of national growth. They connect us to the world, they create jobs, and they enhance trade. Yet, they also bring with them coastal erosion, habitat loss, and displacement of fishing villages. For those who live by the sea, each new infrastructure project can bring them both hope and fear. The real question is not whether development should take place, but how it should take place. What is the true meaning of progress? We have seen positive examples. The Harit Sagar guidelines, for instance, seek to embed renewable energy use, green cover, and emission reduction into port operations. The Kochi Water Metro has introduced electric boats that connect island communities, cut congestion, and reduce carbon emissions, while still serving the needs of the local population. These show us that development can be reimagined. Sustainable transport must not be judged only by efficiency or trade figures, but also by whether it respects communities, protects ecosystems, and includes local voices. Identity is another strand of this discussion. For our tribal communities, recognition has come through constitutional and statutory frameworks. These recognize that tribals are not outsiders to nature, but codependents, with their survival and culture tied to the forests and lands they inhabit. When they are entrusted with stewardship, they bring deep ecological knowledge, responsibility, and continuity. But fisher folk, who too embody this ecological wisdom, remain far less recognized. They know the sea as no one else does, its tides, breeding seasons, patterns of abundance and scarcity. Their livelihoods, their rituals, their very culture depend on this knowledge. And yet, in many instances, their rights remain precarious. Coastal zoning laws, industrial projects, and unsustainable tourism can push them out of the commons they have shared for generations. If recognition is about dignity, then fisher folk deserve recognition not only as workers of the sea, but as custodians of the sea. They must be seen not merely as recipients of welfare, but as rightful participants in shaping coastal governance. Customary practices offer another important insight. Sustainability is not a new invention of the modern era. Communities practiced it through custom long before international treaties or scientific reports. Sacred groves preserved biodiversity, rotational farming practices protected soil fertility, seasonal bans on fishing ensured the renewal of stocks. These were not accidental, they were conscious practices of restraint and respect, developed to preserve balance for future generations. Modern regulation often replaced or ignored such practices, preferred centralized top-down rules. But we are now realizing that the future lies in combining both. Statutory law and customary law must be partners. When formal frameworks recognize community customs, they do not weaken the law, they strengthen it. We see examples in community-managed forests in the Northeast, sacred groves in Maharashtra, and local conservation efforts across the country. Internationally, countries like New Zealand and several in Latin America have found innovative ways of embedding indigenous wisdom into modern legal systems. These are not romantic experiments, they are practical responses to ecological stress. They show us that law becomes more legitimate and more effective when it listens to custom. This brings me to the central role of law itself. The law must not only protect biodiversity, but also the dignity of those who live within it. It must not only respond to scientific evidence, but also to the lived knowledge of communities. It must act not only as a regulator, but as a guarantor of justice. And if the law has to perform this role, then legal education becomes crucial. Our law schools cannot remain confined to textbooks, statutes, and precedents. They must train students to see the law as a living instrument, one that must respond to people and to communities, not just to paper. The Commonwealth Legal Education Association has since its inception worked to make legal education socially relevant. Through comparative research, curriculum reform, and interdisciplinary dialogue, CLEA has promoted the idea that lawyers must be socially conscious, globally aware, and locally rooted. The Kerala Law Academy, by encouraging this conference, has carried that vision forward. It has reminded us that law schools must also be community schools, places where students learn from the people as much as from their professors. The Kumaracom Declaration of last year emphasized integrating law, technology, and ecological justice into education. This conference has taken that vision further by placing indigenous tribals and fisherfolk at the center of sustainability discourse. As we look to the future, certain pathways emerge clearly from our deliberations. First, we must build recognition frameworks that extend legal protections to fisherfolk and other near indigenous groups, ensuring that their voices are heard in governance. Second, we must reform curricula in our law schools, embedding courses on ecological justice, customary law, and community engagement. Third, we must build dedicated research centers within universities, focusing on indigenous and coastal rights. Fourth, we must expand legal aid and legal literacy in communities so that tribals and fisherfolk can access justice at the grassroots. And fifth, we must strengthen comparative dialogue across Commonwealth countries, learning from each other's experience and innovations. What unites all these directions is the recognition that the cause of sustainability cannot be divorced from the cause of subsistence. To protect the subsistence of tribals and fisherfolk is not to choose people over nature, it is to choose people with nature. This is, in truth, an affirmation of a principle long practiced by the very communities we seek to protect. They have always lived with the understanding that the earth is not something we inherit from our ancestors, but something we borrow from our children. For tribals and fisherfolk, this has never been a metaphor. It has always been their way of life. For us, it must become the guiding principle of law and governance. Let this conference be remembered not only for its academic rigor, but also for its moral clarity, that sustainability and subsistence are not parallel tracks, but intersecting lines of justice, that ecological goals and human dignity must reinforce one another, that in protecting communities, we are also protecting ecosystems. I extend my heartfelt congratulations to the organizers, to the distinguished speakers, and to all the participants who have enriched these 2 days of discussion. May the ideas shared here inspire action not only in classrooms and courtrooms, but in communities, policies, and projects across the Commonwealth. Thank you.
Thank you, Lordship, for your words of wisdom and encouragement. Now, before we proceed further, may I invite Senior Professor Dr. S. Sivakumar to kindly present to the Chief Guest, Honorable Mr. Justice Vikram Nath, Judge, Supreme Court of India, the Water Metro report titled Towards Sustainable Transport, a Framework for the Implementation of Water Metro Transport Systems in India. The report has already been presented to the Honorable Prime Minister, Shri Narendra Modi. We have also arranged a few ceremonial honors. May I request to present, Sir, to present Ponnada and Para, a traditional mark of honor, to our Chief Guest, Honorable Mr. Justice Vikram Nath. Honorable, I request sir to kindly felicitate Honorable Dr. Justice A. Jaishankar Nambiar, Judge, High Court of Kerala and Chairperson, Conference Advisory Committee. I request sir to kindly felicitate Honorable Mr. Justice C.S. Dias, Judge, High Court of Kerala and Co-Chairperson, Conference Advisory Committee. To felicitate our organizing committee, I request Honorable Mr. Justice Vikram Nath to kindly felicitate Professor Anil Kumar, Dr. Giri Shankar and Mrs. Ranjini and Professor S. Sivakumar. I request Professor Anil Kumar to kindly come. May I request Ms. Dimple and Ms. Afreen to kindly come to the stage? Thank you so much, sir. As we conclude this conference, may I now invite Ms. Ruchi Sharma D, Joint General Secretary, CLEA, and Conference Secretary to propose the vote of thanks.
It is my honor and privilege to propose the vote of thanks at this valedictory ceremony. At the very outset, I express our profound gratitude to our Chief Guest, Honorable Justice Vikram Nath, Dr. R. Venkataramani, Attorney General for India, Honorable Dr. Justice A.K. Jaishankar Nambiar, and Honorable Mr. Justice C.S. Dias for their august presence today and for their words of wisdom. On behalf of all present, I also wish to place on record our sincere gratitude to Honorable Judges of the Supreme Court of India and Honorable Chief Justices and Judges of the High Court, whose presence has been an honor. I am deeply grateful to Senior Professor Dr. S. Sivakumar, and our sincere thank also extends to Professor K. Anil Kumar for his tireless efforts and support in steering this conference to success. I extend our heartfelt thanks to Dr. Giri Shankar, General Secretary of the Organizing Committee, for ensuring its smooth execution. I further acknowledge with deep gratitude our organizing teams at CLEA and Kerala Law Academy, Dr. Malvika, Ranjini, Dakshina, Nabila, Salman, Dimple, Afreen, Afsharalam, and everyone. Also, I'm thankful to the delegation of CLEA from outside, including Professor Kokila, Professor Rose, Professor Vashanta, Professor Joe Silva and Prashant Barwa sir. Thank you all, and thank you for everyone from the Fisherfolk and tribal community who has taken the time here to be here with us today. Thank you.
Thank you so much, ma'am. I request the students and the faculty members kindly remain seated for the general body meeting of CLEA.
Tea is served on the right side for the participants. Kindly proceed. Participants, judges.